stage. Go ahead, Andy.
Charity trustee and private sector landlord, Chair.
Brilliant, thank you very much.
Private landlord, Chair.
Great, thank you, Stephen. Okay, members, then I'll move on to agenda item 1. Have we any apologies? We've received no apologies. Okay, they'll move on to agenda item 2, which is draft minutes. Members, you'll find the draft minutes of our meeting on the 18th of November 2021 at page 6. Are members content to agree the minutes as drafted?
Agreed.
Great, thank you. Agenda item 3, chairperson's business. Members, just to remind you, the work from home message has been reinforced by the executive this week. I therefore encourage members, where possible, to attend future meetings via Starleaf. Members have also been informed that due to the recent executive decision on holding events, the Minister has cancelled the reception to recognise the success of Antrim senior and minor camogie teams that was due to take place on the 8th of December. Members, also under chairperson's business that I forgot to inform the clerk about, I took place in the part in the housing rights panel debate yesterday afternoon. Where they were to do with the private rented sector. So there were a number of issues highlighted, mainly issues that were already highlighted through our evidence session, but just to let members know that I took part in that on behalf of the committee. I'll move on then to agenda item 4, which is matters arising. Members have been provided at page 17 with a departmental response in relation to the Housing Executive Revitalisation Programme. Officials from the Department and the Housing Executive are continuing to work in partnership to enable the Minister to make a recommendation to the Executive by March 2022 on how to tackle the Housing Executive Investment Challenge. A number of key work streams have been established and all activities within the work streams are currently on target and are in line with the overall programme plan. Members, any comments on that or content to note?
Chair, just if those timescales do slip, if we could ask the department to let us know as quickly as possible. Yeah. Okay,
we can do that. Any other comments or content that we move on?
Content.
Okay, move on then. Members, you'll find at page 22 a departmental response in relation to the Supporting People feasibility study. The Housing Executive has advised that while their executive team has considered the best value feasibility study, it will require further consideration when the Supporting People 3-year strategy has been agreed and a public consultation on the strategy has been completed. This is likely to be February 2022. I find that quite disappointing. This is something that needs to be done, I think, sooner rather than later. But I'll invite any other comment on that, Kelly.
I'm very concerned by this because, as we know, there's a budget process currently being considered by all departments. So if Supporting People feasibility study is not going to be reporting until February, are they included in the budget or not? And we know that Supporting People is going to be hit with a shared prosperity fund. So I'm just very concerned that what we're being told here may not actually be possible by the time February comes. And we know how important Supporting People is. So perhaps, I know the Housing Executive has advised, but can we get an update from the department on what's happening on this? Because if we're waiting on the Housing Executive until February, it may be too late for the department. What is the department considering within its budget for Supporting People? Is there anything going on that way to ensure that we're not going to say to the organisations that deliver this that they're not going to get, they'll only have a month's notice then to be told that they're not going forward or they are going forward, and that's very hard to plan for. Even though it may well be a 3-year budget coming forward, it makes things very difficult for them.
Nope, we can certainly ask those questions. Any other comments, folks, or content that we move on? Okay, then we'll move on. Again, if you could turn to page 23, where you'll see a departmental response in relation to welfare mitigations. Accelerated passage is only required in respect of the draft bill to extend the social sector size criteria or bedroom tax mitigation scheme. The Executive previously agreed to this bill progressing through the accelerated passage procedure. Following the Executive's agreement to proceed with the welfare mitigations legislation at a meeting on the 15th of November 2021, the bill is hoped to be introduced to the Assembly of the week beginning the 29th of November, so that's next week. The Department will shortly be progressing the 2 statutory rules required to extend the remaining mitigation schemes and amend the bedroom tax and benefit cap mitigation scheme to close the loopholes. The Minister will be asking the Department of Finance to agree to a further extension of the current contingency arrangements whereby payments have continued under the authority of successive budget acts until the 31st of March 2022. The response also details of the membership of the Independent Advisory Panel that has been appointed to take forward the Welfare Mitigations Review. Members, again, any comments or content to note that at this stage? Go ahead. Chair,
I'm delighted that we finally now have the independent panel has been announced, and we know that they're undertaking work. My only concern is that we're going forward with extensions to mitigations, which, to be honest, we all want to happen, but I'm just wondering what the advisory panel, that independent panel, is free now to do. I know they're reviewing welfare mitigations, but quite a lot of this is hamstrung by the rules of DWP. We now have these extensions coming forward, so it means then that it's years down the line before this panel's recommendations will take effect. So it would be nice at some stage, if we have time, obviously in the new year, to get that panel in and to discuss any of their concerns about that.
No, I agree with you, and I mean it's something that this committee has been asking for since end of January last year, around the review of welfare mitigations, because we don't know if we're spending the money in the right places, because that review has not taken place, and we don't know, do we need to be then lobbying for further funds to bring about other changes because the review has not taken place. So if we do have time, I would be in agreement with you, Kelly. I think it would be great to have them in front of us, just to find out what their plans are and what their aims and objectives are. Members, any other comments on that, or content that we move on? Content, okay. Members, can I ask you then to turn to page 30, where you'll see a departmental response in relation to the WICT programme. The committee had asked for a list of applicants who were successful in receiving funding under the programme, and that has been provided at Annex A. Members, I was on the meeting yesterday. There was a meeting held for all MLAs, actually, yesterday morning at 11 o'clock from the Department for Communities around this issue and around the future programmes. Really good. Some of the I know a few of the areas that this has been put into, and actually I know the partners that also are there to deliver it, and I'm quite hopeful that this will be very worthwhile going forward. So if any of you can see, I know there may be some areas that haven't been covered, but these are the areas that have been identified, and they've used various statistics to get to identify those areas, including statistics from the PSNI and things like that. So I have nothing further to say on it, but just to look forward to getting a briefing from them as we go along as to how it's progressing. Any other comments on that? No, we're happy enough to accept that and move on? Mm-hmm. Okay. We're going to then move to page 32, where you'll see a response from Derry and Strabane District Council in relation to its access inclusion model. Members, any comments or content to note? Go ahead, Kelly.
I was just actually wondering if this is something that we can pass on to the department, to ask that when, for instance, we have concerns about where appeals are held, or how people are invited along to different venues to attend things, that this access and inclusion model should be sent to the department for their consideration when planning venues, because it's quite comprehensive. It takes a lot of information, and it provides a lot of support actually for businesses and for venues.
Okay, we can do that. Any other comments or content we move on? Okay, we're going to then move on to page 50. Where you'll see a response from Capita to the committee queries on PIP. I don't intend going through the response in each query we raised, and it's a very comprehensive response, and we're short for time. However, I will highlight that Capita have reminded Members of their invitation to meet in person or virtually with any member of the team if they have any queries or concerns around the PIP assessment process or Capita's work within Northern Ireland. So are members content to note that? Yep, okay. Can we move on then to page 55, where you'll see a departmental response to the committee queries on the rates support grant. The rates support grant is not ring-fenced. The department states that it has allocated additional funding of £85.3 million to councils to alleviate projected financial losses and COVID-19 costs during 2020-21. Of this, £35.8 million was permitted to be allocated to council reserves in March 2021 to assist councils in maintaining critical and ongoing frontline COVID-19 support to the community. The department has also secured an additional £10 million from the Executive for councils to alleviate projected financial loss and COVID-19 costs during 21-22. Again, members, any comments are content to note that. I see Mark Durkin has his hand up. Don't know if it's on that issue, but can we bring Mark in? Go ahead, Mark.
Thank you, Chair. Took me a wee while getting in there, but I got on the time for this one. No, that's fine. I mean, and we know what the department has done in terms of supporting councils, which is definitely welcome and was certainly necessary. However, the assistance that they've outlined there was available and given to all councils. The rate support grant, as outlined last week and as we've discussed before, is a specific measure to assist those less well-off councils, and the cut to it affects the less well-off councils disproportionately, of course. So I suppose I'll accept the answer, but I might have another crack at it some other route. It will have severe implications for several of our councils. Okay,
no problem. Thank you. Mark Kelly?
I'm just going to ask, can we get an update from the councils what their positions are at the moment and how they're getting on? I appreciate we have a lot of work on as a committee, but it might be useful if we could ask the department if they can get an update from the councils as to this year's position, because we're talking about, you know, the money was for 2021, isn't it? Yes, but we're looking now at 2021, so it's still this financial year. It's just what their projections would be for this year. Are they okay? And if we ask them about next year, they'll all look for more money. We absolutely know that, but it's just to get a feeling from the councils what their situations are at the moment. And the reason why I raise that is because it's become in front of this committee before that councils are not using their leisure facilities back for the sports groups that we know of. For instance, indoor sports haven't been able to access some of the courts because they're being used for breakout tea rooms because of COVID for staff, or they're being used for Pilates or yoga classes instead of the actual sports needs. So is it a case that they're going for the money as opposed to the purpose?
I know that there was an additional 10 million from the Executive for councils for losses 21-22. So that probably takes us up, I suppose, to the end of March. No, I think you're right. I think we can write to the department and or Solace just to ask what their position is going forward, because it is around that time of the year where they start looking at all of this for striking the rate and all of the rest of that. So yeah, we can get that information. Okay, no one else. I've lost my screen. No, okay, nobody there wanting to ask anything further. Okay, we move on then to page 56 of our packs, where you'll see a departmental response to committee queries on the Disability Strategy Working Group. It will be up to individual departments to confirm their respective contributions to the strategy action plan, and all commitments will be subject to clearance by the relevant minister. The final form and content of the disability strategy remains subject to executive approval. The committee may wish to note that whilst no specific accessibility standards were referenced by the Disability Strategy Co-Design Group in relation to the courts estate, in wider conversations on universal design, members have pointed to BS 8300 as an appropriate standard. The Department of Justice may be able to provide further information regarding access requirements relating to courts estate. Members, any comments on that? Go ahead, Kelly.
This is exactly what I was concerned about. And Chair, you've said it before yourself. If we aim to just meet standards, then we're not actually aiming for the best. BS 8300 is, building regulations for accessibility. It's building regulations. It doesn't put anything on, what support can be provided with someone with disabilities who comes into a building. It doesn't consider things like, can someone walk 250 yards down a passageway to get to the lift, to get to the floor that their appeal hearing is going to be heard on? And that's it. I've been on one of those venues. I'm a bit disappointed that if that's the expert panel coming forward that says that BS 8300 is an appropriate standard, is quite short-sighted. And it's also about regulations for accessibility of buildings. What happens if the building itself can't meet those standards? There needs to be a little bit more teased out on that. And I appreciate that the department has written back to us. I would actually like to write to the expert panel that was involved in the disability strategy to ask them to tease out, is BS 8300 the standard that they're prepared to accept, and what happens with buildings that can't comply with that because they're so old?
Yep. Okay, I think that's a good point, and certainly we can write to them and ask those questions. Any other members, any comments on that, or are we content that we move on to our next item? Okay. Okay, we're going to move on. There we are, that's all that done. We're moving on then to agenda item 5, which is our clause-by-clause consideration of the Charities Bill. 4 members of the committee will now commence the formal clause-by-clause consideration of the Charities Bill. With Martin and Colleen from the department. Members, you have a copy of the bill at page 59, and previous departmental responses to queries start at page 75. Sorry, hold on, you're shaking your head.
Starlife's just shut down, it's opening up now for me.
Okay, so Starlife's shut down, so we don't have...
No, that's okay.
Back up again? You're up again, good stuff. Okay, as I said, you've got a copy of the bill at page 59, and then departmental responses to queries at page 75. A departmental response to queries raised at last week's meeting has been tabled and has a response from the ESR on the delegated powers of the bill. So the examiner feels that the delegated powers are appropriate, and just to advise members that the proposed departmental amendments to the bill are at page 82 of your papers. Claire McCanny from the Bill Office has also joined our meeting. And Martin, before we formally consider the clauses, if we could bring Martin and Colleen in. There we are. You are both very welcome to the meeting today. Good to see you again. Martin, before we formally consider the clauses, just if you could take us through the departmental response to queries raised at last week's meeting, that would be helpful.
Thank you, Chair. Yes, following one of the deliberation sessions, the committee asked if a consequential amendment to the bill could be made to extend the time frame for all appeals to the Charity Tribunal. The department itself had its own reservations and explained that the power to amend the tribunal rules actually lies with Department of Justice. So following that, Department of Justice officials attended the briefing session last week, expressing their concerns at the proposal. They reiterated that the tribunal rules allowed the tribunal to consider out-of-time appeals. They referred to statistics showing that additional time had been allowed, and a recent tribunal ruling which explained that the issues a tribunal would consider in granting such a request. DOJ asked that we forward these documents to the committee, and they were attached to our letter of the 22nd. However, Minister is aware that the committee has received evidence in support of such a change. Therefore, she's instructed officials to work with DOJ to explore the issue further, and she intends to write to the Minister for Justice in order to provide the necessary impetus for this work. We will, of course, keep the committee appraised of any significant developments in this area. During the evidence sessions, the department felt that some of its answers in respect to queries raised around the need for charities to register and the effect of Clause 3 might have been a bit confusing. To reiterate, Clause 3 only introduces a power to introduce a threshold at some future point via secondary legislation, below which a charity would not be required to register, but could do so voluntarily if it wished to avail of the benefits of registration. At present, all organisations which are set up with exclusively charitable purposes and who meet the requirements set out in the Charities Act Northern Ireland 2008 are required by law to make themselves known to the Charity Commission and to register as a charity. However, at the point of establishment, non-profit organisations have choices to make as to whether being a charity is in the organisation's best interests in terms of how it operates, claiming tax exemptions, for instance, availing of funding which is only available to charities, attracting public donations, or whether it can deliver its aims better by operating simply as a non-profit organisation without the charitable status. Should they determine that being a charity is the correct path for their organisation, they will be required to register with the Commission and will be publicly accountable for their actions through the submitting of annual reports and accounts and abiding by all the requirements of charity law. Should they choose to be a non-profit without being a charity, these requirements would not apply. During evidence sessions for the review of charity regulation, it became clear that there is a need for better education and stronger communication on this issue. Minister will be considering how best to take this education piece forward in light of the review recommendations. The committee also raised the issue of Section 167 organisations and their desire to be registered. These are organisations that are established in another jurisdiction but which operate in Northern Ireland. This section of the Act has yet to be commenced. The Minister asked the independent panel to look at Section 167 as a distinct issue, and there will be recommendations brought forward in that regard, which Minister will consider in due course. Thank you, Chair.
Thank you, Martin. Members, any comments or anything they wish? It really is the final stage, because I'm about to commence our formal clause by clause, where we'll read it into the record. I know we had a closed discussion at the end of our committee meeting last week about the appeals and the issue around DOJ, and we had come to the opinion that if the Minister was willing to take this on board and write to the Minister for Justice and start those conversations going, we could live with that. Are members then happy with the response we've received from the department and with what Martin has had to say then today? So in order for us to move on, really is the last opportunity now. If any members do have any burning issues, speak now. No, are we okay then to move on? Mm-hmm. All right, members, I'll take that as a yes. Yep. And I don't see anybody in on Starleaf either. Okay, so members, then we will then now commence the formal clause by clause consideration. Members, I will read out the title of the clause before I ask the formal question on each clause. Okay. If you have any final comments, please alert me at the stage before I read out the question on the clause as to where the committee is content with each clause after drafted or amended. So just to remind members, we can't go back on this once it's done. So I'll move on then to clause 1, actions of Commission staff treated as Commission actions. Can I then ask, is the committee content with clause 1, subject to the proposed departmental amendments? Can I need to hear your voices.
Agreed.
Agreed.
Yeah.
Agreed.
Hold on, can I just double check? Sorry, Chair. I have on my Annex A of our papers, clause 1, page 2, line 31, leave out 42 and insert 91. Surely we're not doing that now?
Okay.
Chair, oh, well, that's for the appeals from the bill, not the...
Oh, sorry, apologies. I just wanted to make sure that's not our 91 then. Yes, okay.
Okay, well then I'm going to ask the question again.
Sorry.
Clause 1, actions of Commission staff treated as Commission actions. Can I ask, is the committee content with clause 1, subject to the proposed departmental amendments?
Agreed.
Agreed? Okay. Then I will read into the record that the committee is content with clause 1, subject to the proposed departmental amendments.
Agreed.
Okay, members, can we move on then to clause 2, power of Commission to delegate to staff? And then can I ask, is the committee content with clause 2, subject to the proposed departmental amendments?
Agreed.
Agreed. Thank you very much. Then I will put on the record then that the committee is content with clause 2 as amended by the departments. Okay, members, with your permission, I'll move on then to clause 3, regulations exempting charities from registration by reference of thresholds. Can I then ask, is the committee content with clause 3 as drafted by the department? Content?
Agreed.
Agreed. Thank you very much. Then I will read then that the committee is content with clause 3 as drafted by the department. We'll move on then to clause 4, short title and commencement. And I then ask the committee, do you agree with the short title or agrees?
Sorry, excuse me, Chair. I think
No.
there's something missing there. Could you just say, is the committee content with clause 4 as
Okay, there
drafted?
is something missing. Committee content with clause 4 as drafted?
Agreed.
Agreed. Okay, thank you. Okay, members,
read
and then
then,
can
the
I just
committee
say
is
that the committee
content.
is content then with clause 4 as drafted? Okay, members, that concludes the committee's formal clause-by-clause consideration on the Charities Bill. Can I thank departmental officials? Can I thank Sharon, Martin and Colleen for their support and patience with our queries, and also Claire from the Bill's office for her support. Okay, I forgot to also ask, does the committee agree with the long title of the bill? Didn't ask that. Okay, then the committee is, thank you, members. The committee is content with the long title of the bill. Okay, members, a draft committee report will be included in meeting papers for consideration at next week's meeting. And members, in your table papers, we have a copy of the draft recommendations for the committee report on the bill. And can I just again thank Sharon, Martin and Colleen for their help today. Members, we are going now to go into closed session to consider the report. So are members agreed that we go into closed session?
Agreed.
All right, thank you.
This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room.
Okay, members, we're going to now move to agenda item 6, which is committee deliberations on the Private Tenancies Bill. Just before I start, I know some members have declared interest. Can I ask for any others?
Chair, I was late at the start of the meeting, so I'll declare my interest now as an owner of a rented property.
Okay, thank you. And all other members have already declared. So, members, the committee will now commence its deliberations on the Private Tenancies Bill. Just to remind members, this is not our formal clause by clause, and Antoinette is giving me hand signals at the back of the room. Oh, right, okay. Oh, David and Eilish are there. All right, okay, right. That's fine. How are we supposed to have more than that? Okay, all right. Well, look, I'll continue here.
Karen Barr is the other name we have.
Okay, and what stage are we bringing them in?
You've got a wee bit to read through.
That's
before you
okay.
get to that
Wee bit,
anyway.
yeah. There's Karen's there now as well, which is. Okay, so I've got a wee bit to read here first. So again, members, this is not the clause by clause stage. We have the opportunity to start today to go through the clauses and comprehensively review with the department any issues raised by stakeholders or committee members, and to ask for clarification on how the bill addresses these concerns and any additional action that the department intends to take on the back of the evidence of the committee has received. So again, just to remind us all, the aim of the deliberations today is to go through the bill one clause at a time, following the 4 themes in the summary of evidence tables, discuss any issues or queries in respect of the clauses from the evidence we've received, identify whether there are any further information, clarity required from officials, decide on whether any amendments are to be considered or whether the committee recommendation or ministerial assurance would suffice, clarify with department if this is something that the minister would be happy to undertake, either ministerial assurance or amendment, and if we do propose any amendments, to be as precise as possible on what we want the amendment to achieve.
Okay.
So, members, you've been provided with paper for this item starting at page 130 of your pack with a copy of a bill. The evidence summary table were reissued as tabled papers as they've been updated to reflect additional written briefings received at Tuesday's meeting and the response from Belfast City Council. These tables highlight for members where proposals and suggested amendments have been made by respondents. The research paper of the bill is at page 193 and the departmental replies to committee queries so far is at pages 3, 4, 6. So then can I welcome David Polly, Eilish O'Neill and Karen Barr from the department who are here with us today. These three of you are very welcome. Good to see you. And also we have Claire McCanny from the Bill Office as normal, who is following proceedings and will be available for the committee for a closed session at the end of the meeting, should members wish to discuss options for amendments and instructions for drafting committee amendments. So members, we will devote an hour of deliberations now, and if we have time later, we will come back to the deliberation. Our members agreed with that we proceed in that manner?
Agreed.
Agreed, thank you. And then members, the questions and comments, just remind you, should be focused on the specific clause under discussion. And if members are content, we'll make a start, and then so just welcome, which I've already done, David, Eilish and Karen. Members will deal with the clauses by theme, and we'll turn to the first theme, which is tenancy management, which is clauses 1 and 2. David, can I ask you to give a very brief overview of each clause? Then I will quickly highlight any specific issues that have come up so far in our evidence on the clause before I ask members if they have any queries or concerns on the clauses for the department. So if you want to go ahead, David.
All right, thank you very much, Chair. Can I start by thanking the committee for having us? Can I also particularly thank the clerk and the team there for working with us? I know that there's an awful lot on, and it's all hands to pumps as we get to the end of the mandate. So we're looking forward to working with you to move this on as quickly as possible, and we appreciate all of the communication we've had so far. When we've been reviewing the evidence that the committee's got so far, the main thing that comes to me is the extent to which this bill is supported by almost everybody. Yes, there's a few areas, but a very few areas where there's some entirely legitimate questions about it. But the general tone of most of the consultation the committee has carried out, which aligns with what we've heard so far, is a concern that in many areas it really doesn't go far enough, and that people want to see more done. So on that point, at the start, I'd want to point out that the Minister's been very clear that the point of this bill is to get on with things that are going to take some time but need to be in place right away to get those things moved on, and that we're going to do a second phase of work, and that second phase of work will pick up a lot of the other issues that people have been talking about. So that would include things like letting agent fees and work to ensure that rents are fair. We're also planning on starting a notice to quit consultation very shortly, which will help the committee in its deliberations and produce evidence about notices to quit and the correct length of notices to quit as the bill goes through passage. But on that, I would ask the committee to note that there is a clause in the bill that allows the amendment of notices to quit later on. But if we start in clause 1 then, so Karen, can you start by reading out what's in clause 1?
Sorry, thank you, David. That's me. I was going to start with clause 1.
You start in clause 1. Sorry.
Sorry. Hello, Chair. Hello, committee. So clause 1 is tenants to be given notice relating to the tenancy, and clause 1 makes it mandatory for the landlord of a private tenancy to provide the tenant free of charge with a written statement of the main terms of the tenancy or any alterations to it within 28 days of the granting of the tenancy. Landlords of private residential tenancies must now provide a document to a tenant which sets out the roles, responsibilities and obligations of both parties. Regulation making powers allow the department to prescribe the detail required.
Okay, thank you, Eilish, for that. Members, so we know that we've heard from many individuals on this, and we've heard about unintended consequences throughout this bill, so I think it's important that we take our time in each of these clauses. So in relation to clause 1, the majority of respondents felt that it is suitable for regulation making powers to prescribe the detail required within such a notice, though some felt that more detail on the face of the bill would be better, so everyone is clear from the start. Mandatory tenancy information packs were suggested. Also, models of such packs and models of private residential tenancy agreements already used by some landlords could be mandated to assist landlords, and also clear requirements for tenants to be made aware of matters both past and present which could affect the property of their tenancy. In relation to the question on whether respondents were aware of details of similar notices or statements of tenancy in other jurisdictions that work well, several respondents highlighted the Scottish model, which requires landlords to provide a written copy of the terms of their tenancy. So, members, can I then ask, have we any comments we wish to make on that, or any further comments we want to ask. Go ahead, Kelly.
Thank you very much, Chair. Absolutely concur with what we have heard from our witnesses. Just to say that the guide needs to be an easy read version provided, and provide links to support for tenants to ensure that tenants know their rights. And I know that we heard from, I can't remember who it was, but that should be provided by the department on NI Direct for easy access by tenants.
Yep, I think they're all good points that certainly, and it was raised. Any other member, any other comment they want to make on clause 1? No? Okay, then Ailish, if you want to make any comment on what Kelly said, or are happy to take that on board and...
We're happy to take that, Chair, and I think we agree there will be an easy read guide. We do intend to have links to support tenants, and this will be available on NI Direct. And I know that it was raised by one of the other contributors that there should possibly be a template that landlords could download, which would set out all of the information, and we intend to have a template as well that will be available for landlords to follow.
Excellent. Good. That's good news.
Chair, just to check, have we anywhere that we can stipulate, as we have heard, that there can be no charge made to the tenant for the production of this, just to make sure that's very clear? That may well be an advice, yeah. But.
Yeah, it is in the clause that the tenant cannot be charged for this, that it must be provided free of charge.
Yeah, thank you.
Okay, Paul, do you
Can I
want
ask,
to
where is that? Where is that within the bill?
Now I'll have to get my copy of it because I have my clause by clause set out here. So
It's under
4A 3. So it says that a tenant must not be required to make a payment in respect of the notice.
any notice. Yeah.
Got it. Thank you very much.
Yep.
Thank you. Yeah.
Okay, look, thank you for that. Are members then content that we move on to clause 2?
Yes.
Okay, so clause 2, tenant to be given notice regarding certain past matters. David, who's going to brief us on this one?
I'm fairly sure this is Karen.
Yeah. Okay, so this links very closely to the first clause. This is just the clause 2 introduces Schedule 1. That schedule will ensure that those tenants who would have received notices under Article 4 of the 2006 order did not do so because of its accidental repeal, and who are still in a tenancy on the date that the bill comes in will receive a notice regarding their statement of terms. So really it's to cover the transitional from when the 2011 repealed the statement of tenancy terms until our bill comes in, to cover those people.
Okay, Karen. Thank you.
So,
finished
Chair,
our
we emailed
frozen?
the clerk about the background to this.
Yeah, okay.
This is there's a gap in the legislation from 2011 to until this bill comes through, and this is to make sure that people in that position who don't legally have to have a statement of tenancy terms get one whenever this bill comes in.
Okay, all right. David, thank you. Members, on clause 2, which introduces Schedule 1, respondents were asked if they felt this clause was sufficient to deal with certain past matters. The majority of respondents felt it was sufficient in correcting the accidental repeal of Article 4 of the Private Tenancies Northern Ireland Order 2006. Housing Rights highlighted that accidental repeal had negatively impacted tenants in a number of ways. Respondents were also asked if there were any other perceived issues in relation to tenancy management that are not in the bill that they wish to highlight in the committee. Among comments received were the key aspects of the Department's 2017 proposals for change in the private rented sector, which relate directly to tenancy management, are not included in this bill. Landlords may abuse the lack of knowledge surrounding the rules for renters, and if a tenant has been, by verbal agreement or otherwise, paying an increased rent for years and proof of the required notice is unavailable, would the landlord be required to refund the increased amount? And then also further engagement with tenants will be necessary to identify effective ways to increase tenants' awareness of their rights. And I know that falls into what we were speaking about there as well in clause 1. Any members have any comments further on that other than what has already been brought up? Go ahead, Kelly.
I just wanted to double check with the department. I know that this schedule refers back to, or this clause 2 refers back to Schedule 1. You see, I know we're to come to it yet, when tenants have provided cash payments, will that also then give them the protections, existing tenants, that if they have been paying in cash, that they can require receipts for that payment?
Yes, they'll be able to require, yes, from the date that the bill comes in, they'll be entitled also to get their statement of terms, which will have all of that in it.
Okay. Not retrospective, just to be clear.
No,
but, yeah.
not retrospective, no.
Okay, thank you.
Okay, any other member want to ask any further question or point of clarification around clause 2? No, any further comment then from yourselves around clause 2? Any further comment from the department around clause 2? That's yourselves when I say yourselves.
We ourselves.
Yeah.
I think, did we want to pick up on the third point you made there, Chair? If a tenant has, by verbal agreement or otherwise, been paying an increased rent for years and proof that the required notice is unavailable, would the landlord be required to refund the increased amount? It would be, this will come in whenever this bill becomes an act, or when it's commenced, and it will basically be a statement of tenancy terms at that point. So, but what it won't mean is that retrospectively, anything that's happened in the previous period somehow or other becomes null and void. That will have been a verbal contract, and both parties will be required to stand over it.
No, and that makes sense. So it does understand that. So do. All right. Anybody, anything more on clause 2, or can we move on then to clause the next set, or the next theme, which is rental payments and rental deposits, which is clauses 3, 5, 6 and 7. So David, first of all, if you could just give us, or whoever, give us whoever it might be, this is great because it's a wee surprise every time. A brief overview on clause 3, please.
This would be me, Chair. We're like a tag team, Karen and I today, covering these clauses off. So clause 3 replaces Article 5 of the 2006 order, and it introduces a requirement that where rent is paid in cash for the landlord of a private tenancy to provide the tenant free of charge with a rent receipt detailing the payment date, the amount that has been paid. If any amount remains outstanding, that amount is to be detailed, or if it's been paid in full, the fact that it has been paid in full. It requires that the receipt must be provided at the time the payment is made, or that if that is not possible, as soon as reasonably possible after that time. It provides that an offence is committed where the landlord fails to provide a notice with the correct information or provides a notice late, and if the landlord has appointed a person to provide a receipt, such as a letting agent, that person, in addition to the landlord, is guilty of an offence.
All right, thank you. Eilish, okay, members, in relation to clause 3, the majority of respondents felt that the clause offers sufficient protection to tenants with regard to the provision of a rent receipt for cash payments. However, it was highlighted that the bill should be amended to provide for receipts to be issued for any other payments, for example, cash for fees, deposits, etc., and this should be specified as required. Respondents were also asked if any particular types of tenants pay their rent in cash, and it was generally more vulnerable people. Among the comments received were that immigrants and some elderly people who struggle with technology, and also some more nefarious people who deal solely in cash. Also, cash payments are more common for older tenants and in rural areas. Also, pensioners, students who go through a private landlord find online using sites like Gumtree, students whose job pays them in cash, and tenants who don't have a bank account, such as international students. And then also some landlords may insist upon rent payments in cash in an effort to conceal income, and that these instances tenants may have particular details in gaining a receipt. Members, I'm going to go to Paul first for comment because he had brought up issues on our last meeting around I think it was to do with the receipts, wasn't it, Paul? So if you want to go ahead.
Yes, thank you. Thanks very much for your presentation. Clause 3, the 2006 order, as you hope to amend it, clause 5, 3b. I'll read out part 3 there. The receipt must be provided A, at the time the payment is made, or B, if that is not possible, as soon as reasonably possible after that time. Given the nature of this clause and given what you're trying to do, why is 3B there?
Okay, I'll answer that one now. In our consultations and deliberations with landlords, they felt that there were some times when a tenant may give them a payment because they could bump into them accidentally, call it their place of work, make a cash payment where they don't have a receipt book or they don't have the means to issue a receipt. So we introduced some flexibility that would allow for a landlord to get back to the tenant with the receipt at a point in time when they are able to do so. It may not, it won't happen where you have a letting agent where someone calls into an office or a landlord has an office. But given that 83% of landlords in Northern Ireland own one or two properties and may have know their tenants on an informal basis, there is potential for a tenant to call with the landlord and make a cash payment at a time when a landlord just isn't physically able to produce a receipt. So it was to allow for that flexibility.
Do you think that would be advisable, that any tenant should hand over money without gaining a receipt there and then? And if you don't, then do you think it's wise to have it in the bill?
I think what we were trying to do was acknowledge what happens and what can happen on a day-to-day basis. I mean, I tend to agree with you. I personally would be loath to pass over cash and not receive some form of receipt. But we do know, perhaps maybe in outside of the Belfast area and more rural areas where landlords and tenants are known to each other and can be and sometimes related or can know each other, be friends, that there can be more informal arrangements that are in place. And what we didn't want was, for instance, and if I could give you an example, the tenants' deposit. Some landlords reported that occasionally tenants would give them a deposit and they have some delay in getting the deposit lodged with one of the schemes, and they asked for a greater period of time to do that. So we didn't want to have something so restrictive that landlords would be constantly being fined by a council for not producing a receipt at the point in time that the cash is handed over due to circumstances that were potentially outside of their control.
Do you think that by having this clause, part clause in this bill, that gives certain licence to landlords to not provide a receipt?
I think the requirement is in the legislation that a landlord must provide a receipt. So if a period of time has elapsed and the tenant hasn't received a receipt from the landlord, this is an offence, and it's a continuing offence. So that if the landlord doesn't provide a receipt and there is a penalty imposed by the council and they still don't provide a receipt, that offence will continue. So there is an offence there. It's not that there isn't an offence if you give a receipt, it's just there has to be allowed for a period of time in which the receipt to be produced.
This is creating a criminal offence.
What is that period of time?
Well, we said a reasonable period of time because it would depend on the individual circumstances as to why the receipt wasn't produced. If it was because it's hard to cover all scenarios, but if it was at a point in time where someone, say, met a landlord as the landlord was about to go on holidays and handed over cash, you could say that a week or 2 weeks would be appropriate because the landlord is not physically available during that period of time to issue a receipt. If it's that they don't get one sent out the next day. Yeah.
If someone was away on holidays, how would you expect them to receive the cash?
So we had an instance for a tenant's deposit where a tenant bumped into the landlord and said, I was on my way to pay that deposit to you. The landlord was packed up and about to leave, put the deposit away in a safe place but didn't get the deposit lodged until they came back from holidays. So there could, what I'm trying to say, probably very clumsy, is we imagine there could very occasionally, we don't imagine this would be commonplace, but there could occasionally be circumstances where the landlord receives a cash payment and they don't physically have a receipt book to give to the tenant, to give a receipt to the tenant at that point in time, but they must do as soon as possible after they've received the cash payment. And it is a criminal offence.
So the defence.
We're creating a criminal offence here. The test of reasonableness is a legal one.
Yeah.
It could ultimately fall to a court to decide whether or not the delay was reasonable. We have to think of all different circumstances. It's not the intention at all to create a loophole.
Yeah,
but if that isn't there, then if those circumstances happen, that person is criminalised.
Yeah, but when you talk about reasonableness, the defence you've given there is that someone is out of the country. It's not necessarily the reasonable length of time. So
It was just one example. Sorry.
Yeah, no, and I get that, but I don't see where you could produce an example of a reasonable amount of time. It would be a scenario where you've left the country or someone has been hospitalised. I just don't see any. I can't imagine any other scenario where someone is handing over cash and they don't receive some sort of proof of receipt. In any formal scenario, and I do fear for this part clause. What I've heard today hasn't really changed my mind, and I'm still of the mind that I think this needs to come out.
If I could possibly give you one example from my own personal experience, and it's a family member of mine who was renting out a property and he had gone to Australia. The tenant had a problem with their bank account. Payments for rent were made via direct debit. There was a problem with that person's bank account. They knew where I lived. They knew that this was a family member of mine, and they called at my home to give me money to pass on to somebody who was out of the country. I'm giving that just as an example. You had mentioned hospitalisation. If someone is in hospital, but then how would you be paying over the cash? It could be passed on to someone to pass on to the landlord. We don't imagine these.
So I get that.
We don't. We don't imagine.
A family member has given you the money. That's informal.
No, it wasn't. It was the tenant who was a tenant in a property owned by a family member of mine.
Yeah.
So it wasn't a family member who gave me money. It was a tenant.
Let me tease that out. So someone gives a third person money. Mm-hmm. That's an informal exchange of money. That third person then goes to the landlord and pays that money. That landlord should still be liable to give a receipt to that third person. That third person then has in their hand that receipt. That third person will then go to the tenant and give that tenant a receipt.
Yes, but in the circumstances that I'm quoting you, the landlord was in Australia, so the landlord wasn't here. I had to make arrangements to get that money lodged into an account.
But someone should have received a receipt at time of payment, which then you or anyone else, third party, could then email that receipt to the person in Australia.
Yes.
So I think
it's not about where the receipt goes. It's the exchange of money, cash, and receiving something in exchange at that time. To me, there's no justification for handing any money over at any time and not getting a receipt.
But I suppose, we're aware of circumstances where tenants have done that. So if we were to take this out, and the circumstance was derived where, for example, a tenant met his landlord at a family do, which happens quite a lot, and gave them the rent, and the landlord didn't have the receipt book, they'd have to say, no, bring that back to my home tomorrow. Or if they met them at the airport, like, in order for the landlord to avoid criminalising themselves, they would have to refuse to take the money.
No, the landlord, all the landlord has to do is refuse the payment.
Yeah, that's what will have to happen. The landlord would have to refuse the payment, isn't it?
And that's quite acceptable if he can't produce a receipt.
Your point is that tenants really shouldn't be handing over cash.
Yes.
If the landlord isn't in a position to give them a receipt. And our point is that in some cases, landlords and tenants, when they meet each other, the landlord reasonably be able to give them a receipt. So that would be the circuit. That would be the consequences of what you're suggesting taking out would be that there would be times whenever a tenant would attempt to pay their rent and would not be able to, because the landlord would want to criminalise themselves. And then in those circumstances, then the next step of that would be that the tenant would be put in breach of their contract and might be making themselves liable.
But I'm sure we all agree that it's not wise to hand over money without getting some sort of proof of receipt. Mm-hmm. So you.
Well, yeah, we all absolutely, and that is the point of the whole clause, isn't it?
Is it not a far stretch to say that a landlord refusing a payment of a tenant because he can't or she can't give over a receipt would put the tenant in breach of a contract?
Well, I think that's legally, technically true, isn't it? But I mean, we're sitting talking about what happens if ultimately, doesn't it? In almost all circumstances, rent isn't paid in cash. And in almost all circumstances, when it is, there will be a receipt provided. We are sitting talking about what may happen in particular sets of circumstances, which are very odd.
Do you have any evidence whereby when cash is handed over from the tenant to the landlord, that money is then claimed not to have been paid?
No, we don't have any information to that effect, no.
Do you think it takes place?
I wouldn't say that it doesn't take place. It's not something that has ever been brought to our attention where a landlord has then said they haven't received a payment of rent from a tenant.
Might be useful to check with housing rights.
And we will check that.
Thing that would cause a dispute, which would end up in mediation and their mediation service or something like that.
Yeah.
Okay, thank you.
We can check that out, so we can. And I think the point was made in committee and evidence gathering there that it doesn't always need to be an actual receipt book, you know, a promissory or a piece of paper to say received on such and such date and signed, could suffice until a proper receipt is given from a receipt book. But I'm going to bring in, I have Andy, I have Kelly and I have Mark all wanting to ask questions around this. So Andy first.
Yeah, Chair, I'm on the same page as Paul with this, but in the position of compromise, is there the option to use the 28 days? I'm not fully comfortable with that, that it must be provided within 28 days and then used, if not reasonably possible, in case of hospitalisation. It's just a thought process. I'm not sure that I would be 100% happy with that, because I do believe that a receipt should be given at the time of payment, but I accept that there may be circumstances where it can't be, but I'd be inclined that no payment should be being made without that receipt.
Yeah, well, that is another option that could be considered, that we would ask you to consider. I thought that myself. If there was a time frame, should it say within so many working days it must be given, unless exceptional circumstances?
28 days has been used in clause 1 in relation to the tenancy agreement, so there's precedent there of 28 days.
No, that's fair enough. I'll bring Kelly and Mark in and then we'll go back to the department. Kelly, go ahead.
Thank you very much, Chair. On this clause 3, my concern is we don't define what a receipt is. So someone could say they can't provide a receipt because they're not at their computer, but to be honest, it could well be a text message or it could be something that is written down. So I would ask, is there a definition of receipt? Because it's not in the explanation and it's not in this. I agree that where on clause 3, where it goes 5.1, this article applies where the tenant of a dwelling house let under private tenancy makes any payment. I would suggest a change, remove of, and change that to comma including rent, comma in cash. So that means that it's all payments. But the other thing I wanted to check is when we look further ahead from this, and this ties into what Paul has been talking about, if a tenant has a complaint that the landlord has not provided a receipt, where does that go? Because it then moves on to continued failure by a landlord to provide a rent receipt, but there is no explanation of where the complaint goes to, who takes that prosecution or anything like that. So I'm very unclear. You know, we can say what we want about a landlord not providing a receipt, but this goes back to the explanation to the tenant. Who do they complain to? They complain to their landlord, but if the landlord, then it goes on to 5ZA and line 2930, it says if a landlord is convicted of an offence, how does it get to that stage? Because I'm very unclear as to where a tenant complains to.
Okay, I think we'll go back after those two questions from Andy and Kelly. We'll go to the department before I bring Mark in because they're pointed questions. So can I ask any response to those?
Okay, on the first one then, on the 28 days, it might be, am I understand that right then, that is a limitation on the definition of reasonable. So an option that we will take, so we'll take away consider this point, but one the suggestion there is that we're defining reasonable as also being within 28 days. So we could say
that's a danger.
At the time of payment is made, or if that's not possible, as soon as reasonable possible after that time, where reasonable is no longer than 28 days afterwards. So we can consider whether or not that would be possible. as I say, like the reasonableness, that's a legal test that could go to a judge. So it's not as carte blanche for the landlord to think of anything and just use that as an excuse not to bother doing it. And it does mean that you have to do it as soon as possible whenever the reasonable excuse lapses. Okay. The second thing on all payments, we'd want to make the point that this is replacing a section of the 2006 order that refers to payment of rent. So we would need to be very careful if we're going to expand it beyond all payments, but we will look at this for the committee.
Okay.
But it would need to be payments in respect of private tenancies.
Yes.
So those would be payments during the private tenancy. So that would exclude any other payments in cash between the two parties, which are probably fairly common between landlords and tenants, because quite a lot of landlords and tenants would know each other, or it might be family and things like that. And it would also therefore exclude any payments before the tenancy begins or after the tenancy ends. Committee will also know that there's separate arrangements for deposits. There has to be written confirmation that a tenant's deposit is protected, so you already get a written confirmation about your tenancy deposit.
I think I'm just wanting clarification because we've taken evidence and we know that maintenance is, payments for maintenance, payments for other services coming in. There have been payments that have been required in cash. So say, for instance, the landlord may the tenant needs work done, gets the landlord to do it and then pays the landlord. So we are talking about the private tenancy. It's connected to their tenancy. It's connected to, so that's why we're looking for all cash payments to a landlord.
Well, those, I suppose I wanted to clarify those things because they've been raised. Actually, I think you raised it during the second reading, didn't you?
Yeah.
So we would want to make sure we're clear what the parameters are, and then we'll consider it. So we'll write back to the committee on that one.
Thank you.
The last one, I think I know the answer, but I hope Ali is about where it goes if there's an offence created.
It's where does the tenant complain to, because that's not listed anywhere in this bill.
So this bill is an amendment bill for the 2006 bill.
Yeah.
Yes.
So the process, we're not replacing that bit of the process. It's already in the 2006 Act. Sorry, the 2006 order, not 2006 bill.
Yeah.
So they would. So a tenant. It says here, if the landlord fails to comply, the following are guilty of an offence under the order. There's an offence there, and it would be up to the local councils to enforce that, as is normal for the 2006 order. The councils would be, they would approach the council, and the council could then go out and fine or fix penalty, whatever it is they're going to do.
Okay, so is that the council where the house is based, or the council where the landlord lives?
Where the tenants live, the property where the tenants live, and they would report it to the council in that area, the council where the property is.
Okay, thank you.
Okay,
And what about
I
that
think there's
receipt?
one.
Well, sorry, you
Yes,
were
on the
going to
receipt,
answer
yes.
about
So
the
there's one
receipt.
last point about the definition of a receipt. The receipt is, what a receipt is defined at 5.2 in the bill in front of you. The landlord must provide the tenant with a written receipt for the payment stating the date of the payment, the amount of payment, any amount outstanding, if no further amount remains outstanding, that fact.
No, what is
so
a
that's
written?
the definition of a
what is
receipt.
What is a written receipt? Because a written receipt could be something that I write on a piece of paper. It could be a text. It could be a printed out thing. It's that, because I don't want anybody to think that they cannot provide a receipt at the time because they think it has to be something else. We're saying it's a written receipt, but we're not saying what format that is. Is it digital? Is it a paper copy? Is it, it could just be one of those receipt books that you buy in a
Well, if I could just come back on that, just to say that I've recently, because we actually were speaking about this and how now even in retail, a lot of people will email you your receipt. And so we're checking with the consumer law to see whether there's already something in the law there that allows for a written to include all of those things. We are looking into that.
Excellent, thank you.
Digital is the way people do things now, so we want that to be included. And just to say, the guidance which sort of sets a lot of this out will be key, and we do know that while it's easy for us to say that the tenant can go to the council to complain, so many tenants aren't aware of where they should go and aren't aware of their rights. So we do completely acknowledge that.
Yeah,
Okay, Paul, you have something very quickly because
Yeah.
I'm conscious Mark's been waiting a while.
Yeah, I'm feverishly trying to look up the 2006 order. So I get your point entirely when you say that you're replacing this clause with a new clause with regards to rent payment. That doesn't stop the department from bringing up a new subsection of a clause 3, which will amend or insert into the 2006 order other payments other than rent. So that's quite within the scope. I would suggest, can I ask the point you make about, well, look, if you're a landlord and a tenant, and we define this as any other payment, well then this could be a friendship group that somebody could owe money, £200 between mates 3 years ago, and somebody's paying the £200 back, and then they may well fall into a trap whereby they are caught in this clause because one happens to be a tenant and the other happens to be his landlord. So I get that. So, but it would need to be then defined that it's purely to do with the property itself that the landlord has and the tenant is enjoying. So surely it's not beyond the scope of the bill and the department to look at that, whereby we would look at other payments other than rent. But I understand why you wouldn't want to. I understand why you wouldn't want to amend this new clause 5, but there is scope to insert another clause into 2006 order, is there not?
Yes, we're content to look at that.
Yep.
We're content to look at it, but I suppose what we just wanted to do was highlight some of the parameters that we would need to consider. But the committees, you've basically now confirmed what you mean, which will help us as we look at it.
Grant, look, can I bring Mark in? He's been waiting patiently. Here we are, Mark.
I'm not sure about. I wouldn't say patiently, Chair, but I've been waiting, and cursing is all the points I was going to make are being made. But there are a couple of other ones just there in terms of what would be acceptable or what is acceptable as a receipt. The notion that a landlord could just scribble something down in the back of an envelope or a cigarette packet and give it to a tenant on receipt of cash, if it was given to them unexpectedly, that doesn't afford any protection to the landlord. So maybe if we did look at sort of defining a minimum standard of receipt, because like say a landlord receives the rent, scribbles something down on an envelope and hands it to the tenant, there could be a dispute further down the line wherein the tenant could say that they didn't receive a receipt, and the landlord would have no copy themselves of it.
Yes, Chair, can I just, what we'll do is we'll check with consumer law, because the definition of receipt, in my mind, surely is going to be well defined in consumer law. And then we'll come back to the committee with some information about exactly what. But the member makes a really good point. The point of a receipt is that both parties have it. Yeah, not just that. In this case, the tenant has it, but the landlord needs to have a copy too.
Yeah, absolutely.
And then just one other wee thing, and it's on Article 5.5. Provides that an offence is committed where a landlord fails to provide notice with the correct information or provides a notice late. If the landlord has appointed a person to provide the receipt, that person is also guilty in such circumstances, in addition to the landlord being guilty. So that's there, an agent. So if an agent hasn't done their job, the landlord is guilty as well.
Yes. And I think this was to prevent landlords from abdicating any responsibility for making sure that the agent they employ to look after their properties is doing their job properly. So they have a responsibility to make sure that their letting agent or whoever's acting on their behalf is complying with the legislation, and wouldn't be enough to say, really not my responsibility, and pass that off as being the letting agent. So that's why it's an offence for both parties.
Letting agents provide tasks. I mean, they provide services on behalf of landlords. So the landlord is choosing to discharge their obligations through a letting agent.
Yeah, so they don't have to be chasing after someone every month or doing receipts and stuff every month, but and I think now they really do or should be getting something maybe from letting agent every month, I suppose, that the evidence that the receipts have been issued and rent received. No, that's okay.
No,
Thank you.
thanks, Mark, for that, and thanks for highlighting that point, because sometimes we can get lost in protecting the tenant, and this is also to protect the landlord as well. So I think that was a good point that you brought up also. Are members content that we move on? We could move on here to clause 4 if they're happy. Yeah.
Yeah.
Okay. All right. Surprises, and let us have a brief overview of clause 4, please.
Okay, so it's back to me. Clause 4 then is limit on tenancy deposit amount and breach of the tenancy deposit limit and recoverability of excess. The new clause limits the amount of deposit that is required in connection with the private tenancy to no more than 1 month's rent. The clause provides definition of 1 month's rent in cases where the private tenancy does not calculate rent monthly, and makes provision concerning the recoverability of excess. Provides that a tenant or other person who has paid a tenancy deposit or had a tenancy deposit retained can recover the deposit to the extent that it exceeds 1 month's rent.
Okay, thank you for that, Karen. Okay, members, respondents were asked how appropriate did they consider the limit of no more than 1 month's rent on the amount of deposit that is required in connection with the private tenancy. There was general support from housing groups and tenants, but among comments received were that the welcome for the limit of no more than 1 month's rent on the amount of deposit that is required, and an important first step in addressing affordability issues faced by private renters. They also said that this is good in terms of not allowing landlords to insist on more than 1 month's rent in normal circumstances. However, there needs to be provision to allow a deposit of more than 1 month's rent in certain circumstances. And also this is absolutely necessary. 2 or 3 months requirements stop poorer people from renting. There was also a call for restriction on the amount of rent requested in advance, as this could be used to circumvent the limit of the tenancy deposit amount. However, there were comments from those in the sector that landlords needed the protection of greater than 1 month's deposit in some cases, and must be confident that the cost of any damage beyond wear and tear can be recouped if a ready supply of private rented sector property is to be maintained. For example, a larger deposit for a pet has often been seen as a safeguard against the associated risks. Okay, members, I'm going to open up to members again if they have anything further they want to comment or ask of the department on this one. Any members, anything further on that? I know from the Housing Rights Conference yesterday, there's still a lot of people for whom 1 month's rent is a lot of money to get together. So it'll not suit everyone. Though I do think there was general overall that 1 month is certainly much better than what has gone before. So there's no member has indicated they want to. Sorry, Kelly, go ahead.
I know that it isn't dealt with in this this clause, but I just wanted to assure myself. This deals with deposits. It doesn't deal with advance rent. So I'm just wondering. I know we have been told, and I just want to assure myself that this will be dealt with in the future legislation that's coming forward about how much advance rent would be asked for. Yeah, okay.
Yes, that's 100%, yeah.
Yeah.
So this is deposits. The point of a deposit is it goes into the tenancy deposit scheme. It's the tenant's money, and everything being equal and everything going well, they will get it back. Yeah. It's different to advance rent, which is an advance payment for a service that to live in the house that the tenant will get. You know, it's the landlord's money.
But absolutely, the point about advance rent will be covered when we come to the whole area of fees and charges and letting agents fees and charges that will form that a part of that bigger piece of work.
It does fall into the general area of barriers to access to the private rented sector, which is what, as the chair alluded to, discussions around this focus in the general area of barriers and people's inability or to actually access a private tenancy in the first place.
And can I just tease out as well, this was brought up to me by an agent. So what the landlord, the agent as opposed to the landlord, is the person who puts forward the money into the tenancy deposit or the tenant deposit scheme. legally, who is the requirement to do that? So the landlord obviously is the owner, and they employ an agent who is supposed to put that money into a tenant deposit scheme. Legally, if at the time when the tenant is leaving, that money is not in the tenant deposit scheme, you know, how does the tenant get the proof of that? Who is legally required to deposit that into the tenant deposit scheme? Is it the agent or the landlord, or are they both liable?
So I think we're flicking madly through the private tenancies order here to to get to the bit about tenants deposit scheme. Sorry, if you bear with us.
No problem.
I suppose this is a good chance to say that we should be reading this along with the order at all stages, us included.
I haven't.
Scheme information required. Prescribed form.
Yeah, we would know you would, Paul.
I couldn't find it, so in the order.
I mean, you can come back to us on that one if you.
Part 2, 5A.
Part 2, 5A, Paul says.
Tenancy deposit schemes.
Yeah.
Yeah.
Yes. That's the landlord who receives such a tenancy. The tenant is going to
More than I explained it.
Yeah. Sorry, can we come back to
Yeah,
that?
look, that's not a problem.
Yes, thank you.
Come back to us on that,
we all think,
that point.
I think we all think we know what the answer is, but we want to check it.
No, and we want to have a definitive answer on it. Is there anything else that was highlighted there on what I had read out that you just wish to comment on?
I suppose just to agree that this is one of the areas of the bill which has had quite a lot of discussion. The department feels it's very important to ensure that people have access to private tenancies and that there aren't unfair barriers put up. Landlords have made the point that they generally don't charge more than a month's deposit, but in some cases they do. I suppose it will fall to the Assembly to decide what amount is reasonable. There's broad support for a cap and a limit on it. Just to finally then make the point that this came out of the consultation whenever we were talking about limiting notices to quit. And the point was made by tenants that given the power relationship and that landlords have the power, that landlords would merely ask for more deposit and notice to quit therefore might not actually, a longer notice to quit might actually be a disbenefit to tenants because it would stop them getting a house in the first place. Which is how the department was led to make legislation in this area.
And can I just say as well, this thinking about restricting deposits and things like that has to be balanced against any impact on supply and keeping landlords in the sector. So, you know, that's why we're limiting deposit. We're not looking at rent in advance right now, because we're trying to keep the balance as well. We know there's good landlords out there as well, and we don't want to be bringing in too many regulatory things to drive them out. So,
could I just ask a clarification question with regards to some of the witnesses that we had heard from, that they would like to be able to ask for more than a 1 month's rent in particular circumstances, and the chair has mentioned about pets. I'm very aware of, under the Disability Discrimination Act, is there a potential that assistance dogs would be treated in that way, and therefore anybody with a disability who happens to have an assistance dog would be required to pay more of a deposit than someone who doesn't have a disability? Is there any way that those particular circumstances can be written in a way or something defined that protects people with disabilities?
At the minute, within our clause, it's the amount of deposit that can be, that there are no exemptions. So the amount of deposit that a landlord can ask for is limited to 1 month's rent in advance for any tenancy. So at the moment, under this bill, there isn't an exemption whereby they can ask for an increased deposit if a person has a pet.
Okay.
So I suppose there will be nothing in the bill going forward that means a landlord can ask for additional money. But
can I just check that's the member's question then?
If there was if there was an amendment, say, or a consideration of a deposit of more than 1 month's rent in particular circumstances, that those particular circumstances couldn't be in breach of the Disability Discrimination Act, where an assistance dog, a person with a disability who uses an assistance dog would be liable for that type of increase. They have an assistance dog because of their disability.
So, we haven't got any exemptions.
No.
So you couldn't charge more to have any type of pet, never mind an assistance dog. But if we were going to put an exemption in that you could charge more deposit if the person had a pet, if that decision was made, then we would then want to, I'm presuming,
But that's only
make that exemption not apply to anyone who has an assistance dog. But we haven't thought that through at all because we haven't got any exemptions in it.
No, we haven't, and we've received communication from some pet owners who feel that they're being discriminated against at the moment because they're being asked for more of a deposit, and they want to make sure that they can't be asked for more of a deposit. But it's a really interesting point that you make, because I'm wondering if a landlord advertises a property and says no pets allowed, but you have someone with a disability who has an assistance dog, and they don't get a tenancy because the landlord won't let pets. I wonder, would they be? I'm sorry, that's aside from this, but I'm just wondering, would they be breaching the Disability Discrimination Act?
It is a very interesting point.
It is a very interesting point.
Beyond this bill, but if you could imagine that could end up in court, even just given existing legislation that's in place.
No, I appreciate that's outside of this, but maybe something to think about advance rents for the future, where something might be brought in that way. But no, thank you on that one. Yeah.
And we do know, just to follow on from Kelly's point, we do know, because it has been brought up here, that landlords are asking for extra deposit if there is a pet. So it is happening, and I know we're saying here in the bill that it shouldn't be any more than 1 month's rent. But we don't want landlords finding ways around, and they will find ways around it when it comes to pets, because people with pets are entitled to homes as well and want homes also, and they will pay the extra to enable them to have a home. So it will happen along the road there somewhere, just to highlight that. Nobody else has asked to come in on any more specific points on this one. I'm going to go on, I'm going to carry on, and we'll see if we can get through clause 5 before we break as well. So clause 5 is increase in time limits for requirements relating to tenancy deposits. So very briefly, if you could just give us a quick brief on that.
Yeah, this is an extension of the tenancy and deposit scheme. So this clause 5 amends Article 5B of the 2006 order and extends the time limits for a deposit to be protected in an approved scheme from 14 days to 28 days, and gives additional time for a landlord to provide the information to the tenant, and amends Article 6B from 28 days to 35 days. And this was something that came out on the consultation with landlords around protecting a deposit, and they wanted some extension from 2 weeks to 4 weeks to get the deposit protected.
Okay, that's grand. Thank you. Just some of the comments we had, that respondents were asked if extending the time limits that's outlined in this clause are sufficient and necessary, with the majority stating that they agreed that they were sufficient. However, there were a number of comments that the clause appears to be designed for landlords and or agents of several properties where the tenancy change at specific times of the year. So we know that happens frequently, especially around students and various times like that. So just any members, any comments on that further? No, I don't think there are. If members want to comment, anything that you would like to come back with around the committee comments there?
No, Chair, just to say that this wasn't designed specifically for larger landlords or those landlords of large HMO properties where there's maybe a lot of students. It was to accommodate any of the landlords who had raised this with us during our review period.
Okay, thank you, Mark. I'm sorry, Mark Durkin wants to come in. If I just let Mark come in first, in case he's a question for you. Come ahead, Mark.
Thanks, Chair. It's just a wee query. See, in terms of Article 6B and the amendment from 28 days to 35 days, given for a landlord to provide information to the tenant, is it therefore that's determined as a reasonable time?
Yeah, well, that's set down. Those It's not it doesn't state in the clause that it'll be a reasonable time. It's set down that they must give it within 35 days of the deposit being protected. They must notify the tenant of where their deposit is, who's holding it, and what sort of a scheme it's being protected in.
It places a duty on the landlord.
It places a duty on the landlord to do it within the 35 days, yeah.
But therefore, we must think, or the department must think, that that's a reasonable time
Yes.
within which they should do so. And
Yes.
just for consistency across the bill, might there be merit in bringing it back into the other clause where we were having the discussion around reasonable time?
Right. Okay, yep. Yes. Around the receipt and the reasonable time for giving the receipt. Yeah, yeah.
Well, I suppose, Eilish, we consulted on this, didn't we?
We did.
So the 35 days is to provide the information. So if we're given 28 days to make the deposit, there's a week after that to tell the tenant that the deposit has been made. So those two can't be the same, if you follow.
So then the 28 days was reasonable.
So the 28 days is reasonable time for the deposit to be given to the tenancy deposit scheme, and then the 35 days is you get another week to tell the tenant, to send a letter to the tenant confirming that. So that's what the 35 days is.
Yeah.
So
but it is
28 days it's more consistent throughout the PTO. Really, the 28 days would be the more would probably.
But it is. But it's a good point in terms of if we said 28 days is a reasonable period to protect a deposit, to reflect that in the other clause where there has been queries around, a reasonable period of time where we haven't set down a period of days that we said we're gonna look at again.
Thanks, Eilish.
Absolutely.
Okay, Paul, did you want to come in on a point there?
Just on this clause 5, it's completely different from what our argument was before, I believe. And I know Mark is trying to get you on the consistency part as to what is reasonable. But in this case, what we're doing in clause 5 is we're amending 5B of the 2006 order, and those periods of 14 days and 28 days are in that bill, and that'll be basically common practice. And all we're doing here is extending the time for the landlord to produce what they need to produce in both cases. So it's not really the same argument, to be fair. And I can understand why you're stretching that period out. So I don't know that I would have any complaints about clause 5 and what it actually does to the 2006 order.
Okay.
There we are. Okay, folks.
Thank you.
Anything further you want to add on clause 5, or will we draw a halt there to our proceedings, and then if we have time at the end we'll pick up on clause 6, because clause 6 might have a bit more clause 6 onwards we'll have a bit more discussion, I imagine, around it. Are everybody content with that? Yeah?
Yeah.
Okay, look, thank you, David, Karen and Eilish. We hopefully will see you in not too far away if we get through business. I know, David, you're staying on for the next item of business as well. You're sucker for punishment. Yeah. So if just bear with me, I'll just, what page number am I now going to? Page 22. Yeah. Okay.
Yeah.
Right, members, we're going to then move on to agenda item 7, which is departmental briefing on increased housing options. Members, you'll find the briefing paper at page 361 of your meeting pack. And then welcome back David Polly to our meeting, and then also welcome Paul Price. These are both good to house both here with us today. Can I ask you then to go ahead and give us your brief, please?
Thank you, Chair, and good morning, Chair and members. Thanks for the opportunity to be here today with my colleague Paul Price to brief you on the Department's work of increasing housing options. So,
right, can I just stop you there a minute, Paul? Have you got your speaker on? Because I think we're hearing David through your speaker as well.
Do you want to mute?
If you can mute until you need to speak, that would be great. Well, we'll give that another go, David. Sorry, go ahead.
I'm David Polly. I'm the Director of Housing Supply Policy Division, and with me is Paul Price, and he's Director of Social Housing Policy and Oversight. And our aim today is to provide you with information on what steps the Department is taking to increase housing options. So we're going to take you through a range of initiatives and areas of policy that are currently being delivered or developed, and after that we'll be happy to answer any questions. Firstly, I want to talk to you about the efforts we're making alongside our partners and stakeholders to improve options for those experiencing homelessness. It's important that we learn the lessons from what worked well during the pandemic. will be through initiatives such as the Housing Executive's new homelessness strategy, which has just been launched for consultation, and we can build on these experiences. It's essential that we continue to focus on prevention rather than management, and the homelessness strategy, alongside year 3 of the Department's Interdepartmental Homeless Action Plan, will help us do that. Alongside delivery of these strategies, we continue to act right now to help those who need our support the most, and this includes the provision of temporary accommodation for those with no recourse to public funds. And this has been facilitated during the pandemic with a memorandum of understanding between the Housing Executive, the Department for Communities and the Department for Health for the duration of the COVID emergency, and it's currently in place until the 31st of December 2021. We've asked for that to be extended. In addition, the Department continues to work with the Housing Executive to implement its reset plan, which is called The Way Home, Homelessness Response to COVID-19, and we've secured $9 million of funding for the delivery of that this year. I'm going to pass over to Paul now, and he'll address the key aspects of social housing provision.
Okay, thanks, David.
Okay, so our main mechanism for addressing housing need is the Social Housing Development Programme and the building of new social homes. And this is obviously a very big capital programme for both the Executive and for the Department of Communities. And for this financial year, it has a budget of 162 million, which has been secured to deliver 1,900 new social homes. That's the starts target for this year. That figure of 162 million is a substantial increase, I think 26 million on previous year's funding, and it is the highest annual budget provided to social housing new build for at least 10 years. In addition to that budget of 162 million, in recent weeks, it was maybe 5 or 6 weeks ago, the Minister has approved up to an additional 15 million, so taking the total budget up to a total of up to 177 million. And that's additional support available to housing associations who are working with the construction sector to build new homes and are facing a headwind in this year of unprecedented volatility in material costs. And so that extra money is, if you like, to shore up the resilience of the programme faced with delivering 1,900 starts in the face of that those spikes in costs for materials, particularly wood and metal. So in addition to, so if you like, keeping the programme going on a day-to-day basis, particularly in view of this year's target, we're looking at ways, should we get increased budget in future years, to increase the capacity of the programme. And the Housing Executive has been asked to bring forward proposals that would significantly increase capacity to supply new social housing. It's fair to say that if we just try and push money into the programme as configured, we will face a point where we will not be able to expand the budget and deliver all the homes that have been prioritised through that budget. And the key, I'm happy to take questions on this later, but the key things around this are maybe expanding the role of the Housing Executive, looking at introducing ring fencing, particular actions to address increasing rural supply and land acquisition. Indeed, the provision of suitable development land in areas of housing need is one of the key challenges to development, and the Department is working with the Housing Executive to identify surplus public land that could potentially be used for social housing developments. And as always, through the commissioning process, it encourages housing associations to identify and secure sites in areas of housing need. We're looking also at increasing social stock through the acquisition of existing residential and non-residential properties. That will, particularly in non-residential properties, require appropriate planning and council engagement. But there is the potential to increase housing stock. There are core significant challenges around water, sewage infrastructure for the development of social housing. It's particularly a concern looking forward. So we continue to work with the Department for Infrastructure and Housing Executive colleagues to establish options that minimise the risks of the current network capacity of the network to deliver the new build programme. So that's very quickly what we're doing to try and increase the supply of new social homes, both in the immediate and the longer term. But in addition to that, we have to make the most efficient use of the stock we have. And to that end, the Minister has approved almost all of the recommendations from the recent review of fundamental review of social housing allocations. And the Housing Executive has now started the implementation of these. Implementation of some of the 20 proposals will actually start in this financial year. Overall, reform of the schemes for implementation of all of the recommendations from the review will make allocations fairer and better at responding to objective need. The Minister has also sought to protect the existing social stock through changes to the sales schemes. So last year's Housing Amendment Act resulted in the closure of the sales scheme for registered housing association tenants. This follows a transition period which ends on the 28th of August 2022. That was specified in the Act. So at that point, the scheme will end and tenants will no longer be able to buy their homes from their associations. And that will help to protect the social stock we already have. Members of the committee may recall that within the narrow scope of that Housing Amendment Act, it was not possible to consider the larger house sales scheme operated by the Housing Executive. But options are being considered for the future of that scheme. And this forms part of the Minister's plan to protect and maximise social housing supply, in line with the cross-executive consensus on the need to build more social homes and meet housing stress. I'm happy to take questions on that. Finally, I will briefly mention the work the Minister is progressing to revitalise the Housing Executive, and the committee last week, I think, will have received an update on this. This is probably our highest priority in my directorate, and it involves significant effort in a very short period of time. Work has proceeded at pace since Minister Nakulin delivered her statement to the Assembly in November of last year. We are working very closely and intensely with the Housing Executive to deliver on the Minister's commitment to bring a recommendation on the future of the Housing Executive to the Northern Ireland Executive by March 22. And we're on track to do that. I mean, it's vital that a solution is found urgently for the Housing Executive so that it can continue to provide quality homes for those in housing need now and into the future. That's my brief account of what's happening on the social side. I'll pass back to David for a few words about what's going on beyond that.
Thank you, Paul. If I can start with Ownership then. Ownership is a hugely successful organisation which has helped over 30,000 people into home ownership, and the Minister recently approved over 150 million to deliver more than 4,400 shared ownership homes by April 2024 through co-ownership. Co-ownership is also developing other products in addition to its traditional shared equity model, which will offer alternative ways into home ownership for families and people. One of these is rent to own, which is funded by 12.5 million FTC, and that supports the purchase of supporting the purchase of more than 80 homes for rent and eventual purchase by households who are not ready yet financially to purchase a home, even through shared ownership, for example, because they can't get mortgages. Co-ownership is also developing a specific shared housing product for the over 55s, which will support people in this age group to downsize, move into accommodation which is more suitable for their needs. In addition to shared equity, rent to own and over 55s product, the Department has also delivered the Affordable Homes Loan Fund. And this was done in partnership with 3 housing associations. This is going to deliver around 200 homes by the time the pilot ends in March 2022. And building on the lessons from the Affordable Homes Loan Pilot, we'll be in the process of developing a replacement new build shared ownership model, which is most likely to be funded using financial transaction capital. I also want to talk about some of the other types of housing options that we have in development. The first of these is the new intermediate rent product, which can provide a solution for households struggling to meet market rents. Intermediate rent would be new to Northern Ireland, and in terms of tenancy duration rent costs, it would be situated between social and private market rents. It seeks to provide high quality, well managed and affordable homes for rent for tenants who cannot or do not wish to access home ownership, or will be unlikely to attain sufficient points to have a realistic chance of accessing social housing in their area of choice. And you might recognise it from other places where it's called similar types of things are called affordable rent, mid-market rent or cost rental, and these intermediate rent models have been operational across the UK and Ireland for some time. Council's local development plans, which mandate a percentage of affordable homes new developments, are going to be an important part of our toolkit for increasing housing options. Intermediate rent can help support this ambition. The committee will be aware that public consultation has just launched on our intermediate rent proposal. Together with the initiatives we're developing right now, we're developing a 15-year housing supply strategy which is aimed at tackling the long-term barriers which are constraining our ability to improve options and increase supply. The strategy acknowledges the whole system issues which act as barriers to supply, whether you're building a social, affordable or a private home. Land availability, decarbonisation, planning, skills and infrastructure are just some of the issues the strategy will seek to address. Key element of the strategy is a recognition that resolving many of these issues cannot be done by this department alone, and we're working extensively with officials from other departments, local government, the third sector, voluntary and community sector, housing professionals and private developers to find solutions to these issues. In really simple terms, Paul and I are housing directors, but the quality that a house is built to is building regulations at the Department of Finance, and where houses are built is planning, which policy rests with DFI and which is delivered by councils. So the whole system, it's a whole system approach, and it includes an awful lot of departments and other partners in trying to make the whole system work as well as it possibly can to deliver the houses that we need. We know as well that we need to align with other key strategies, and that includes the Executive's energy and green growth strategies and the Housing Executive's homelessness strategy. And these provide the long-term basis for sustainable improvements across the entire housing market. A public consultation of the draft housing supply strategy will be launched shortly. The committee will of course be notified in advance of the consultation, and we can come and brief you on that if you require. Finally then, it's important for me to highlight the key role of our private rented sector and the role that it plays as a place for housing many people, more than the social sector now, we think. We know improvements are needed, and the committee is in the process of scrutinising the Private Tenancies Bill just before and possibly at the end of your committee meeting as well. And for that reason, I'm not planning on talking too much about that today, but it is an extremely important part of our housing mix. It's one that a lot of people live in, a lot more families. It's not just about students, it's not just about HMOs, and it's not just about South Belfast. There are a lot of people living private tenancies all across Northern Ireland, more than living in the social sector, and about twice as many families with children as live in the social sector. A lot more older people, a lot more people with disabilities. And it is one area that we need to look at, and the department is proposing to look at it in different phases. We're talking about the first phase, but there is more regulation needed for the private rented sector as we move forward. So I'm looking forward to working with you in this bill as we move it through the Assembly. So just to finish then, the department is committed to increasing the range of housing options across all tenures to ensure that everyone has access to a quality, affordable, sustainable home. Thank you very much for inviting us, and Paul and I will try our best to answer your questions.
That's brilliant. Thank you, David. Thank you, Paul. Members have indicated prior to the meeting that there's various topics that we want to hone in on a little bit. So I'm going to go to members first. I'm going to go to Andy first, and then I'm going to go to Mark, and just remind members if they have any supplementaries on what either the two members are asking, please do let me know as early as possible. So Andy.
Thanks, Chair, and thanks, David and Paul. Throughout your presentation, you'd mentioned the availability of land. Therefore, I know it's not the FC lead, but are you able to provide any update on the public land registry?
Yeah, this is the DOF. This is the land registry, the work that DOF are doing in LPS. Yes, it's online. They're working through the department. So obviously, those who had good digitisation of their land. I think it's already online. You can go and look at it. Do you want me to? I can send the link for that through. So a lot of BFC land is already on it.
Okay, yeah, no, that'd be helpful.
I mean, yeah, but they are working through, and as I'm sure you know, other departments and other parts of government, they didn't have digitized land, so they're actually having to go through paper records and things like that. So things like that will take longer. But I can send through some information that we have on it to the member.
That'd be helpful. Appreciate that. And just on another point then, in relation...
Just 1 minute. Kelly, was yours on a supplementary on that point?
Yes, it was on the land registry.
Mind, Andy, just if...
Sorry, Andy. It was just to tease out on this. I've been trying to do a wee bit of work on land banking myself and comparing it across the nations. My concern is that councils are being left off that piece of work. Now, I know we can't force councils to hand over land, but there are significant pots of land owned by councils that could be released for housing. Is there any actions being taken by the department to identify with councils where land can become available? Because we do know that departmental land is quite limited, but councils, on the other hand, do have significant parcels of land in different parts of Northern Ireland.
Yeah, there is. Okay. The Minister has asked us to start work with councils, and we've written to Solace is to see how we can bring councils into the work that's going on around public sector land. And to be fair to councils, some of them have proactively come to us and said that their members have asked them to see what they can do about their land. So Belfast, as you might know, has been auditing its land holdings with a view to trying to find land that it can use for housing. And Newry and Mourne and Derry as well are quite proactive in this regard. So we'll be taking that work forward over the next while.
I'm just thinking about that rural proofing, because the areas that you've mentioned are quite urban. It's just to ensure that where councils have rural land, that we can streamline that and create.
So we'll work. Those are the three councils who've proactively been who came to us, really, who proactively came to us. And it will not escape you that those are councils that have a focus on housing stress. There's quite a lot of housing need in those areas.
Yeah.
So their elected representatives are obviously quite aware of that and have asked what the council can do to help. But the work we do will be done with all councils, including the rural ones.
Okay, thank you.
And I also know Antrim and Newton Abbey as well have been working on that, I know, through our own councillors and trying to identify some land and working through that through their community planning as well, as to where housing is placed and services are placed. So I do know they're actively, so councils are, we might not know all about it, but there certainly are conversations taking place. Andy, sorry, if I go back to you then.
No, you're okay, Chair. Second point in relation to the budget exercise, and you'd highlighted about the uplift in the House build budget by some 26 million, the biggest uplift in 10 years. Is it likely that that's going to be maintained or at least increased over that budget period?
I can't answer that question at the moment, Andy. That's really a matter for the executive as it concludes the budget planning process, which I believe it will do in the next few weeks. So we'll know the answer to that then. We've bid in line with the Minister's intention to expand the programme. Okay. We'll see what the outcome is.
Okay, so I appreciate, obviously you're waiting on the executive coming back on this, but the bid that was put in as part of that exercise, was it maintained at 162 or was there an increased bid?
It had a trajectory increasing the starts target from 1900 up over the next 3 years and increasing the budget accordingly, yeah.
Can you give any information on the level of the increase?
Of the bid, I think that probably would be a bit, I'd probably not know, but it's fair to say it was an increase.
Okay, appreciate that.
Right.
In terms of the revitalisation of the housing executive, and you'll be aware I've raised this, is there any more detail at this stage on any potential implications, especially around the cooperative mutual body aspect that's being considered?
You asked me, can I tell you where we're heading?
Yep.
Well, pretty much.
It's because I know you get what you get from us as process updates. It's really difficult to give you more than that because obviously what we have to do here is reach our conclusion, engage with our minister, and then brief the committee. So we haven't got to that point yet. So it's really difficult for me to tell you where we're heading. But the minister is clear. We have a series of constraints within which to develop options, and a preference stated for a cooperative mutual solution, and we're working within those parameters. Sorry, that's all I may say at the moment. Are you hearing me okay? Because I noticed that my lip sync is completely out with what I'm seeing on my screen.
Yeah, I'm struggling a bit, but we'll get through, I'm sure. I appreciate, obviously, you can't preempt or predetermine, obviously, what decisions, but we obviously seen in terms of ONS reclassification of our housing associations, and that obviously causes some concern in relation to the approach that we might take there. So you can appreciate why I'm asking those questions. Has there been anything raised from that in terms of the functionality and how that will interface with government in terms of the cooperative and mutual type body?
It is the heart of the matter. We cannot develop policy with ONS. They do not do that.
No. We are looking with as much ingenuity and innovation as possible at, because one of the key constraints the Minister has given us is that we should change as little as possible whilst
The key issue being really opening up the ability for the housing executive to borrow. So we are doing that, which is more process update for you, I'm afraid, and I apologise for that. But to say more than that would be now to start to preempt before we've really engaged with our minister, before we've finished and before we've engaged with our minister.
Yeah, no, I appreciate that. I'll move on then on that respect, unless anybody's supplementaries, Chair.
No, nobody's indicated. Andy, go ahead.
You mentioned as well, David had mentioned about a whole system approach of how obviously housing cuts across various different departments. How is that coordinated? Is there high level stakeholder group across the departments?
Yeah. The housing supply strategy has been pulled together by a programme board, and it includes senior civil servants from all the relevant departments. So that would include Department for Economy with respect to energy, decarbonisation and energy strategy. It would include Department of Finance, it would include from various different aspects, 3 or 4 different bits of LPS are engaged. It would include Department of Infrastructure, the planning policy people there. There's some other people on it, there's some independent voices as well to make sure, to keep us honest. So that's how that process is being taken through, and we are planning on doing an executive strategy. So ultimately, we have written to all the ministers about that. The ministers nominated people to that group, and the idea is to get an executive strategy because it is so far beyond just DFC.
Okay, no, I appreciate that. In terms of the rent to own and financial transactions capital, I'm sure you'll be very aware that the Finance Minister had highlighted the availability of some 66.7 million in the October monitoring round remained unallocated, and he encouraged other ministers to give consideration to opportunities to draw down that. Has DFC given any consideration to other avenues where they may leverage this?
We are working as hard as we can to use as much FTC as we can. Housing is the main vehicle for using FTC in Northern Ireland, and we are trying to make sure that we take the best advantage of what's available to Northern Ireland of the FTC budget. The only other main area which is using it is the Northern Ireland Investment Fund. Other than that, it's mainly being used by housing, and we are developing other products. Those other products I talked to you about, the aim of those is to try and make full use of our FTC consequentials that come across. Most of FTC is available because of housing interventions in England. Things like first-time buyer loans and things like that, they have FTC consequentials. So it's mainly because of housing policy in England that it does come over to Northern Ireland in the first place. And housing is a good way of using it because it is a loan, it has to be paid back. And housing, there are established models as to how that can work. So it is our intention. I mean, we are one of the main users of FTC. And it is our intention to keep on developing products and make sure we absolutely take advantage as far as possible of all of the FTC that is available to the Northern Ireland Executive.
Thanks, David. And in terms of that, how many products are currently live with the department utilising FTC?
So co-ownership is the main one of those different loans.
Yep.
The Affordable Home Loan Fund is coming to an end, but we're going to learn the lessons from that and roll out new products. We also have the rent to own, the over 55 product should be coming online soon, and I'm hoping to make a loan. And we're also looking at some other products with homelessness third sector organisations so that they can buy move-on accommodation or housing first type accommodation for people who are currently living in hostels.
Okay, so
who are ready, tenancy ready.
Is it likely we'll see DFC bidding for some of that 66.7 million FTC?
I already have bid
you
for
have
it.
Already?
Yeah. So I didn't mention intermediate rent, and then as well, which I talked about in the presentation.
And can you give any more detail on the bid, or is it premature in relation to that FTC?
Part of the bid is based on what we've already committed to co-ownership, so that's no secret.
Yeah.
You know, we did a 4-year funding deal, so I mean I know there's FTC available, but I mean 32.5 million of that every year is already going to co-ownership. I can't remember. I mean, the intermediate rent, we're still doing a public consultation on how we deliver it, so there's no actual hard and fast bid in yet for that.
So part of the bid that's in is for co-ownership. Is there bid in for something else that you can speak to at this stage?
Well, we intend to fund the over 55s product. There's already been an announcement made on that. We are funding the rent to own. Other than that, I mean, bear in mind as well, some of these things, we are working through third-party delivery organisations and we're trying to drive the best bargain we can from them. So co-ownership is not entirely funded by us. It's partially funded by private finance.
Yeah.
So what we pay is as little as as little as the public sector needs to pay to get the policy intent, and then the balances can be picked up. So there is there's a commercial reason why I'm not always telling you, as well as a process reason as to why I can't necessarily tell you exactly what we would be intending to fund things that we haven't properly developed yet.
Appreciate that, David. And I'll move on to my final point then.
Kelly just wanted to ask a wee supplementary, if that's okay.
I just wanted to ask David, with regards to FTC, could it be used to upgrade empty homes to make them habitable again? We've heard other witness sessions and spoke to other people about, the number of empty homes that are out there that need work done to them. Is that a revenue, or can that be brought into FTC? And also to ask you, with regards to heritage buildings in particular, I know that in Scotland there's a capital fund that is used to upgrade those buildings to bring them back into habitable use, or change them to habitable use. Is anything being considered with FTC to reuse old buildings but make sure that they could be compliant with energy and environmental standards?
I know in some places they've considered using loans which could be funded from FTC rather than grant for heritage, but that isn't our part of the Department for Communities. That would be Historic Environment who run those programmes. I don't really know if they have considered that or not, or whether or not it might work. I mean, obviously the issue with the loan is that the impact can be less than a grant if it can only cover a certain shortfall in viability, whereas a grant could conceivably cover a lot more. So it goes without saying we aren't talking about FTC for social house building because it can't make up the subsidised loan and the terms of repayment, the preferable terms of repayment. They offer some level of state aid, but not enough to properly subsidise a social home, for example. So they won't work for everything. On empty homes were part of the Affordable Home Loan Fund pilot. Some of that 200 homes that I mentioned does include refurbished empty homes. So it did work to an extent. The extent to which it fully met the policy intent or actually brought that many empty homes into use, or where they were, or to what extent they were used for people in housing stress and things like that, were a lot less clear. We did write to the committee about the Affordable Home Loan Fund review, didn't we? So we're not proposing to keep on doing that. But in principle, the model did work.
Yeah, I'm just worried.
In some cases.
Yeah, I'm just worried because I know in my constituency there are a number of areas where there are empty homes that are owned by private landlords, and instead of actually re-establishing them as usable homes, there's new social housing opening up new ground instead of concentrating housing in an area where there are services, there are supply, and there isn't an issue with Northern Ireland Water. We're actually cracking open new ground to build more instead of making better use of what we have. I just wondered if FTC could be, there could be an application based on that.
I think last May, published a review of our empty homes work in the department. So it covers quite a lot of these things. I mean, the key learnings are, from the point of view of empty homes, is in terms of housing supply, they're not necessarily there are not very many of them in the right place. A lot of them are rural. A lot of them transition through anyway. The number of empty homes, the data comes from LPS, would cycle 20% of them would be added or removed from the list every year. Okay. About 20% of them are tied up in complex legal proceedings and things like that, and that's why they're empty. So once you start to get into them, each one has an individual story, and it can be extremely complicated and take a long time to take the home and get it back into use. So in terms of significant increases of housing supply that are going to make any great difference to housing stress, they're quite often, it's an awful lot of trouble for one or two houses. So if you want to do stuff at scale, it might not always be the best way forward. The other thing was in a lot of cases, the economics of it would take quite a lot to tempt somebody back into using a home, or maybe even if they could be tempted into, because quite often there's complex reasons why not. That report's available online. Yep. You might be interested in it.
No,
in
I was
terms
just
of
wondering if
FTC for some of them can make up for viability. In many cases, though, in most cases, it's not financial viability that's stopping them coming back into use. I should also mention DAERA has responsibility for dereliction. So there are two sides to empty homes. I mean, there is the fact that they are a nuisance, they can attract antisocial behaviour, things like that in areas. And if it's from that point of view, DAERA is proposing a review of its dereliction legislation, I understand. I mean, I've answered this entirely from the point of view of housing supply. No, is it value for money and value for time for the department to invest a lot of time and effort into trying to get individual empty homes back into use? And given all the work that we've done and we've established that how difficult that is, how complex that is, and for how little reward you get out of it.
Yeah, I'm just worried about this 55, the over 55, which is, you've said 200 homes, the displacement of someone from a community where they have lived. There may well be a number of empty houses in that area, but then they would be displaced wherever these 200 homes are.
So that would be a DIY. I mean, they would choose the house they want to live to, they want to move to.
Okay.
So in the market research ownership did, quite a lot of people would have wanted to move to a more accessible home closer to family.
Okay.
But it would be entirely up to them where they went to. We wouldn't be talking about building houses somewhere else and moving old people off to them. And this would be a proactive choice that older people do, possibly in preparation for older age.
Okay. I know that I have a whole, may as well call it a village set up in the Arts Peninsula that's over 55s houses that the private sector has set up. Unfortunately, the lack of access to services is not helping the over 55s that live in it, but no, thank you very much for that.
Okay, Kelly, thank you. Andy, you had another point you wanted to bring up as well?
Sorry. Just the last point, David, on the Affordable Homes Loans Fund. In your briefing document there, you mentioned it's expected to deliver 200 of the 600 target. Is there any particular reason why it didn't deliver on its full target? And also it's mentioned that it faced challenges from its inception. Are you able to expand on those challenges?
Yeah, we had an independent report done on it.
Yeah.
It was the first use of FTC, really. We worked through 3 housing associations and we tried different things. Some of them worked better than others. In general terms, I suppose it was all a lot harder than we thought it was going to be. Getting those empty homes and getting them in the right place and things like that, I think it was quite a lot of work. Now, Clanmill worked on the empty homes and they have met their target. We also, part of it was about new build of shared ownership. So as you know, in ownership, you go and find the house that you want, and then ownership helps you buy it. This was about building houses that would be shared ownership, getting them built to the right quality, getting them in at the price point. Social house builders were doing it. There's a difference between the private housing market and the social housing market. Things like that just proved to be a lot more difficult than we had envisaged, really, at the start. And so we ended up having to change what we were going to use it for and things like that. In the end, one of the housing associations more or less gave us almost all, if not all, of the money back, because they were unable to deliver anything that they'd committed to at the start. One of the housing associations gave most of the money back, and only one of the 3 housing associations more or less used all of the loan that we had made to them. So there is a big lesson there that we want to work the other way around. We will want to design things where we're fairly sure that there's a product which will work before we fund it. But the Affordable Home Loan Fund was successful in the sense that a lot of lessons were learned that we're now basing our intermediate housing policy on. And if it wasn't for that, we would be just about to make a lot of those same mistakes again, I would suggest. There are 200 families in houses that might not otherwise be, and the independent review said that it was better than really doing nothing and not trying to start work in this space. And also, of course, these are loans; they will be repaid. No money was lost to the public purse.
Okay. What was the full amount spent on that? I know it's loans; it'll come back, but how much was allocated and how much was returned?
All of the money will be returned if it hasn't already.
No, I mean, as in you'd said
by the end of March 2022.
They didn't spend it on the project, so how much of that was returned without being spent?
I'll send you that information rather than trying to find it now.
Okay.
That's okay.
And what was the overall budget line for that programme?
Rather than me trying to remember and getting it wrong, I'll send you that information to you. It was in the region of 6 or 7 million.
Okay. I'll leave it there, Chair. Thanks.
Okay, Andy, thank you for that. I'm going to bring Mark Durkin in. Next, if I can bring Mark in.
Thanks, Chair, and thanks to the guys for the presentation. On the empty home stuff, I've been going to come into a lot of it has been covered now, but it would be useful to get that Affordable Home Loans Fund report. I'm sorry, I missed it when it was published, but 200 out of 600, and while there might have been lessons learned, that's expensive lessons, maybe not in terms of the department because the money will come back, but it's harsh lessons for those out there waiting desperately for homes. So I think it's important what lessons are learned are applied very soon. To me, like I'd asked a recent Assembly question, and the answer that I got back, you'll be aware of it, was that there's somewhere in the region of 20,000 vacant homes here, and not all of them will be in rural areas, David, obviously. And while I appreciate that it might be effort intensive in terms of identifying where would be suitable, which properties would be suitable, which would be easiest to acquire and to get ready for habitation by social housing tenants, I think it's definitely work that does need more work done on. I know, like Yusuf says there in your paper, there's opportunities to add to existing stock through acquisition of vacant properties is being explored. I wonder, could we hear more about that? And that was in reference to non-residential properties as well as residential properties, but it just seemed to me that are you viewing some non-residential properties in terms of office blocks, and that will be basically redundant now, given the new way of working that many companies and departments have, that will be easier because it'll be all under one roof rather than a house here, a house there, and two in the next street.
Shall I comment on that one? I mean, the Housing Executive is looking at whether, particularly in areas of high housing need, where land availability in terms of increasing supply is a problem, could it reacquire stock, residential or non-residential, for the purposes of meeting that need? Now, the difficulty with this is demonstrating its value for money in comparison to the existing model of funding an association through grant funding complemented by its borrowing to produce something. But the fact is that if that model can't operate in these areas, then an alternative, regardless of its cost, may be the only value for money way of meeting that need. So we're looking at that. That hasn't finished. Proving the value for money point on this has not finished, but that could be a way of making the case for the Housing Executive reacquiring properties per se in these areas. You will have an issue. We will have an issue of planning terms about changing the existing use. We'll have to work with councils on changing the existing use for non-residential properties. But David referred to some of the work we're doing. We are encouraging councils in their planning decisions as much as possible, within what is possible within planning policy in Northern Ireland, to prioritise social housing in every way possible. So you would hope that if we can make the value for money case, we could get the kind of existing use planning decisions out of councils. But it's fair to say this is work in development, and it's difficult to say more at the moment.
I'm just thinking in terms of vacant properties, and I've got a further breakdown of actual housing executive vacant properties, and there's actionable voids, and they have to be kept for decampments and such. Like, given the work that's going to be required, it's not in my own constituency, but on tower blocks and so forth. And there was a recent announcement from the Minister and stuff she'll be doing or hopes to do in North Belfast, an investment there. That's obviously going to have a huge impact between now and the work being commenced, never mind completed, in terms of homes there being allocated. Would that be correct?
Well, the the tower block strategy, broadly speaking, has 3 phases, and according to those, it stretches far into the long term. It keeps a substantial number of our 33 blocks for a period over the next 15 years. Those that are scheduled for demolition, the plans will involve decanting and finding alternative homes for those who have been moved. It's difficult for me to say more than that, Mark, at this point. It will have a displacement effect, but the case for the demolition per se has been made very carefully with consultation in all cases, and the putback will be as appropriate as is possible given density issues. And that's pretty much all we can do.
Yeah, but I'm just wondering, in the interim, whether these are earmarked for demolition and reconstruction, will housing providers be holding on to properties, rather than allocating them in the short term because of the decampment that's going to be required for the demolition?
I'm sorry, I'm not sure I understand the question. Why would housing providers hold on to? Maybe I'm missing something. I'm sorry if I'm being obtuse.
Any properties that they have in that area currently, should they become vacant? Say the housing executive, they'll obviously be conscious that, well, if those tower blocks are going to come down, we're going to need non-actionable voids to decant these people into. So are they building the properties to do that?
I can get you, if you're specifically talking about upper Long Streets, I can get you with the detail on that from the housing executive. But generally, the housing executive has, in comparison to any comparable housing provider, an incredibly low number of voids, and its turnover timing between tenancies is pretty good. So the amount of slack in its stock is, in comparison to other providers, very, very low.
Well, then we are.
I'm happy to get you details about the Upper Long Street's plans for decanting.
Yeah, because we'll have to be radical then in terms of decampment options, I suppose. On the house sales scheme, I was just wondering where we are in terms of the housing executive. I know it's next August, isn't it? The door shuts on the housing association one. Has there been any evidence of an upsurge in terms of people buying homes that are from housing associations, or do you anticipate one over the next 9 months or so before the scheme closes altogether? And when is the housing executive one looked at? I think since we debated the issue, since the legislation was passed by the Assembly, the housing executive have hemorrhaged another 400 odd homes, and associations maybe 120 or something, which is more than a quarter of the homes that we're building at the highest rate in 10 years. And that's just absolutely, completely unsustainable, as you'll agree, I'm sure.
Yeah, there has been in the sales scheme, particularly in the housing executive sales scheme, which is by far the bigger, there has been a significant increase. We are getting correspondence about the ending of the association sales scheme. I don't have the figures on what's happened to its much smaller scale, but any spike there would be probably paid into insignificance compared to the housing executive sales scheme. I'm happy to share with you the figures on sales generally for the last year, if that would help. They do show a spike generally, and that is to be expected because of the discussions around closing both schemes. The proposals the Minister has to end the housing executive sales scheme, the best thing for me to do is probably refer you to what the Minister said in the Assembly, which reflects the fact that this is a matter that's with the Executive. The Minister has developed proposals, and they are with the Executive for consideration prior to a consultation. I think the committee, we have briefed the committee, I think, on proposals the Minister has for the housing executive sales scheme. But that's where the blockage is at the moment.
Okay, thank you, Paul. And I know a couple of my colleagues have touched there on the over 55 shared ownership idea. I was just wondering, in terms of that, like it is shared ownership or rent to buy. I can't recall the exact terminology there that you used around it, even though it's in front of me here somewhere. But the envisaged difficulty, I suppose, at times for people in that age bracket, albeit it's not that old these days, but mortgage companies might view that differently than you and I do. So what kind of over 55s are we talking here? Like, you don't really envisage people leaving social housing units where they have secure tenure to go and saddle themselves with debt and trying to buy somewhere or co-own somewhere at that stage in their lives. So what's
It'll be people who are owner-occupiers whose home is unsuitable for them really to live in as they age, which is going to become an increasing issue, and but who can't get a mortgage because they're coming to the end of their careers or aren't working anymore, and mortgage companies won't give. So they're sort of stuck in their home, notwithstanding the fact that they have a lot of equity. And the proposal is co-ownership then will work with them, and they will use whatever equity they have in their existing home plus the co-ownership portion to allow them to buy a more suitable house. And that more suitable house, you would imagine it could be level access, it could have wider doors and things like that. A degree of this, or a downstairs bathroom, a degree of this will be future-proofing by people. You know, it makes sense to do these things before there's some sort of health crisis. And then there will be no need for them to staircase out on when they can, if they want to. So they can keep on buying more of their own home, so they own more of it and they can pass it on to their families. But I mean, ultimately, co-ownership is in this for the long term. So if co-ownership stays there until the person passes on in 25 years, co-ownership will get its share of the house back when the house is sold after the person passes on. So that's the basic model, and it's to try and get over that thing that older people quite often need to move home but can't get a mortgage. And now for some people, they have a big expensive home and they can sell it and they can downsize, and that's fine, but other people aren't in that position. They might own a home which wouldn't allow them to move to a more suitable home. And co-ownership's research did point out as well, one of the issues around that, it is about location. People want to move closer to families as well, which would be another advantage of it.
Okay, thank you, David. And finally, now, with the Housing Executive in on Tuesday, giving evidence on the Private Tenancies Bill, and I asked a couple of questions around temporary housing in the private rental sector. I'm just wondering from a departmental view, trying to get one, if there is one on that. It seems to have disproportionately high rate of properties in what private rental sector are being used for temporary or emergency accommodation, and obviously I don't know, is that more lucrative or whatever, but it is having an impact on people's ability to get secure tenancies. So how do you view that, or is there a way to cap or reduce at least the amount of properties being used as temporary?
From our point of view, and I think the Housing Executive agrees with this, we ideally wouldn't want to be using as little temporary accommodation as possible. But for various reasons, I mean, you'll know the longer term was that there was quite a lot of work done to reduce, in particular, the use of B&Bs and hotels, but also temporary accommodation, and get people into secure longer term accommodation as quickly as possible. That had been having some success until the pandemic, but since the pandemic, for various reasons, there's been a massive increase in the use of temporary accommodation. We don't want anyone to be in temporary accommodation. People should be in their long-term home. And the long-term answer to that is around things like there being more long-term homes available. It's about social house building. I also mentioned in passing, some of the homeless organisations are looking to become landlords themselves and move people into accommodation out of their hostels. And if somebody can be moved out of a hostel and somebody can come into accommodation from a hostel and get support. Temporary accommodation, it's more expensive, and it doesn't get people the support they need to get their lives sorted out and get everything stabilised and move on out of their episode of homelessness necessarily. So we want to reduce it as far as possible. The Housing Executive is also carrying out some work to try and reduce the cost given the amount that it's using. I do know that it does cause quite a lot of pressure, especially in the HMO sector for other people, if we start using more than this. I suppose ultimately the Housing Executive has a statutory duty to house people who are found to be homeless. it's a pressure on our budget as the number of people who fall under that statutory duty here living in temporary accommodation goes up, because it has to be met. So that's
Yeah, and
that
there's
is
a lot of
the statement
COVID
of
cash
position
to
we're in.
help. There's a lot of COVID cash to help deal with that, and that's the goose that laid that golden egg is going to be cooked very soon. So what will that mean for the situation? Do you have a lot of people now, that you have in maybe B&Bs, hotels, people in houses across the north, that the amount that the department have or the housing executive have to pay their rent will be reduced significantly come the next financial year?
I mean, there is going to be a pressure on the homelessness budget going into next year, because you're right, we funded 9 million extra, and whereas I can put my hand on my heart and say a good chunk of that is to be used for prevention work and things which will actually help people move through their homelessness. There's no two ways about it. A lot of it has been used for additional temporary accommodation. One of the reasons for that is that the capacity of our existing temporary accommodation is reduced. I mean, there's less people in hostels because for infection control reasons. The Public Health Agency has said that we can't go back to having the same density of people in some of the hostels. There are there are rooms in hostels being held for isolation and things like that as well. So yes, there is. I mean, there is a continuing pressure on the homelessness budget, and it's been there for some time, and we're hoping to address that during the current budget exercise.
And will be my final point or question, but one of the concerns I might have is because people have been scattered sort of here, there and everywhere, and do temporary accommodation that might not be available in the city or town that they're from, so they're sent somewhere else. Then if and when secure accommodation or permanent accommodation is becoming available in their new location, by virtue of their points, they're up at the very top of the list. Will get priority when homes are being allocated, which is inherently unfair on people from that area who might have been on the list for years. And that brings me back to the question, I suppose, in terms of the social housing allocation or housing selection scheme. The intention is for implementation of a number of proposals to be underway by the end of this financial year in terms of being better at responding to objective needs. Be at liberty to disclose any of those new proposals?
Well, the ones that will be implemented by the end of this financial year do not include the proposal to weight points towards time waiting. That will take a longer term. Overall, all 18 of the proposals the ministers approved will be implemented across the next 3 years. I should point out, so it's probably the lesser important ones in terms of addressing that situation that will be implemented this year. I mean, we have budget to implement the changes to the selection scheme for this year only at the moment. We are, of course, as with everything else, bidding for the budget to implement the further changes, but we would need those bids to be met for that implementation to follow. So it is subject to budget.
And sorry, Paul, could you just remind us what those changes are this year?
They are the smaller scale ones. They're to do with things like the principle of no detriment, I think, is one of the major ones, which is the idea that your points can never change even if you have a change in circumstances. But I can write to the committee on those that are planned for implementation this year. We've asked the Housing Executive for that detail recently. They only got funding in year to start implementation, so we haven't yet been advised by them what exactly will be started this financial year. But as soon as I can, I'll get that to you.
Super, Paul. Thank you. Thanks, David.
Can I just pick up on one last point about empty homes that the member mentioned at the start? I'll resend to the clerk the empty homes report that we have, and in the back of it there's a map. We mapped where the empty homes are. So you'll see that whenever I sign, it's 93% of them are in areas of low housing need, but you'll see where they are. They're spread out completely across the countryside. Less than 3% of the empty homes are in areas of high housing need, and the rest are in areas of medium housing need. But when you see the map, you'll understand what I mean.
Okay.
These are houses where, there was an old farmhouse and the children built houses next door, and then the parent died, and there's an empty house in the middle of a group of family houses and things like that. A lot of them are entirely unsuitable. It'll also explain It also points out things like the number of empty homes fell by half between 2006 and 2016.
But it hasn't changed much since 2016.
I don't think it's changed much since 2016. But those numbers from the House Condition Survey, and it's going to be run again next year, so we will get a new figure next year. But
okay,
there were a lot of empty homes before which have come back into use.
20 or 3% of 20,000 is a significant number of homes as well, though, when it comes to actually addressing housing need. That's the point I would make.
I'll send it through, and I look forward to discussing it with you more.
Okay, thanks, David.
Okay.
Okay, thank you for that. Does any other member have any other issue that they want to bring up along while they're here in front of us? Is there anything else, Andy?
Yeah, Chair, can I quickly ask, in respect, obviously we're currently going through the private tenancies, and another issue that was raised is the homelessness duty in relation to the housing executive and the 28-day point. Is there any consideration around that at the moment?
Yeah, I'll answer that, Chair. That is a different piece of legislation. As you know, the private rented sector, the Private Tenancies Bill is amending the 2006 order. So I'm not sure we're going to be able to do anything during the process of that bill that would change that. However, we are separately reviewing the homelessness legislation to see whether or not anything there could be changed to make it more useful, and that has been raised in that context. So if there are sound homeless policy reasons to change the 28-day support, we'll pick it up during that exercise. I should also mention, because whenever I talk to the housing executive about this, they always make the point that the Housing Option Service is not bound by that 28 days. That 28 days relates to the full duty homelessness application, so the Housing Option Service can help somebody find a home or at any time. You don't have to wait for 28 days to contact them, and they'll be able to help you long before that.
Yeah, but the issue here, and the reason I mentioned the private tenancies is the whole potential change to the notice to quit. I'm fully cognizant of the fact it's a different piece of legislation, but the issue here is, and we'll all be familiar with this, is when you have somebody who interfaces with the housing executive, quite often they are threatened with homelessness before that 28-day period. The housing executive can carry out all of the internal work in terms of gathering the respective evidence, but they can't actually consider that person for full duty applicancy until the 28-day point, which seems ludicrous. When the reality of it is that person's... Go ahead.
So, I mean, the homelessness legislation, you have to either be homeless or in threat of homelessness, and the threat of homelessness is defined as, imminently homelessness, and that is defined as 28 days, and that's set out in the homelessness legislation. So, if there are, in conversation with the housing executive, it is definitely worth a discussion about whether or not that's a suitable length of time, or whether or not we could look at it again. So, as I've said, we have started work to review all of the homelessness legislation, and that's been picked up through that. And when that's more developed, then it would be sensible for us to come and talk to the committee about that.
So that's not likely to be changed at any point in probably the next mandate before we will see any consideration onto that?
It would definitely be the next mandate, yeah.
Okay. Yeah, it's something that I would like to see changed. It's something that I know is causing a particular problem out there, and I appreciate obviously the threat of immediate homelessness, but it is an area where if that person was able to get the FDA points, that they could move on. It does cause a lot of stress. Yeah, I'll leave it there, sure.
No problem. Can I just ask a follow-up on homelessness in general? Do we have any figures, or do you have any figures at hand there of officially how many people we have that are declared as homeless? Because we know from our constituency offices the vast amount of people that come through us that are the hidden homeless, that don't often are added on to those statistics. So have you any figures there? Can you supply us with some figures around that?
I'm really struggling to hear. It's a bit patchy. I don't know if it's the same for you.
Yeah. Can get that, I'm afraid. I'm really sorry.
Sorry, Chair.
No. Paul, do me a favour. Paul, would you mute yours again, just because we're getting your feedback as well? No, sorry, David, I was just asking there on homelessness and the amount of stuff that comes through our offices on hidden homelessness, which is a major problem. Just do you have any figures at hand, or can you send us figures through of those that are officially classed as homeless?
Yes, it's available online. The department does two publications: a homelessness bulletin and a housing bulletin. One's every quarter and one's every 6 months. So those are available on the department's website, and they include a breakdown of homelessness by type and by reason for homelessness. So that would be what is already available, and a lot of people. When you say hidden homelessness, that would include people accommodation not reasonable and things like that, who are likely to stay in their existing house.
Yeah. No, well, that's okay. Look, if you can send the links through with that. Andy, you want to come in as well?
Yeah, can I just, it's a completely different question. It's another question I want to ask. I'd probably keep the guys here all day, to be honest, on housing. Obviously, we're quite aware that we're in the midst of a cost of living crisis, and particularly a fuel poverty crisis in respect of the significant energy increases. You mentioned the stock condition survey earlier on, and there are particular challenges in relation to the funding. Are you able to provide any update in relation to steps to improve the cavity wall insulation in housing executive properties? Because that is a particular issue.
Paul, you're still on mute.
No, I'm not. Can you hear me?
Not now.
You're not now.
Okay, sorry. That's really about the housing executive's ability to deliver their cavity wall action plan, which is investment sensitive. It needs us to address fundamentally the housing executive's investment problem for it really to move beyond a response-led approach to the cavity wall issue in their properties. So we go back to the fundamental problem about trying to find a source of income for the housing executive over and above its rental income to address the backlog and give it the ability to invest long term in its stock.
Yeah, and I appreciate why fundamentally it is a matter for the housing executive. It should be a matter for all of us, because the reality of it is people are heating their homes and it's going out through the walls due to poor insulation, cavity wall, etc., loft insulation, whatever that may be. So it is a particular area. I appreciate obviously the various different strands of work around revitalisation to be able to enable the housing executive, but I just wanted to know if there was anything the department were working on in particular schemes or initiatives.
Well, no, not at the moment. We have obviously the affordable warmth scheme, which is outside of the social sector, is funding interventions that improve the thermal efficiencies of the home. But in the social sector, I'm afraid it is about until we can really solve the investment problem, cavity wall insulation issues will be dealt with on a response basis, which will be minor in scale, because properly addressing it wholesale has to be part strategically of a large-scale investment program that will deal with all of the investment requirements of the home in the appropriate sequence. So at the moment, it's a response-led, and that's all it can be.
No, I appreciate that, but it calls into question poor asset management. But I'll leave it there, Chair.
Okay, Andy, thank you. No other members indicated they want to ask anything further. So, David and Paul, thank you very much for your time today. And David, we will maybe see you later, depending on how we get on with our next briefing session.
I'll just hang on in,
That'll do.
Sorry.
No problem. Go ahead, Paul.
It just occurs to me that there is, of course, the EDRF investment that the Housing Executive is making with the European Union to look at insulation in no-fines properties and non-traditional properties. That would be one instance where we're investing, I think, about €45 million over the next few years to try and improve the thermal performance of those homes. But apart from that, it's response-led. Andy, sorry.
And sorry, just on that, Paul, how many homes is that?
Gosh, can I write to you with that detail? I could guess, but I'll probably be wrong. It's I'll have to write to you about that.
Yep. Can you provide detail of that? And also, I noticed the handy heat scheme that the housing executive are rolling out. Would you be able to provide us with more information on that?
Of course, we'll do, yeah.
Appreciate that. Thanks, sir.
Okay, thank you very much. I think you've been left there with plenty of stuff to forward back to us. So thank you so much for your time today.
Thank you. Thank you, Chair. Thank you, members.
Bye, bye,
Thank
bye.
you.
Okay, members, we're going to move swiftly on then to our next agenda item, which is agenda item 8, the Northern Ireland Turf Guardians Association, and this briefing will be our first briefing on the Betting, Gaming, Lotteries and Amusements Amendment Bill. Members, you'll find that at page 369 of your packs. So, Janice, my screen has gone funny here, so I can't see where anybody is. So can I then welcome to our meeting today, and I know I've seen their names sitting there, but they're a wee while. So Paul McLean, Gary Toll and Michael Fee. Can I just ask you guys, we have terrible feedback. So I know it'll not be from Michael because you have headphones in. So the other guys, you're going to have to put yourselves on silent a moment. You mute. Paul and Gary. Up there. Okay. Hold on. Yeah, that's better. We haven't got the feedback. Sorry about that. It just happens whenever two people are in the one room to do a briefing, we end up sometimes with dreadful feedback. So we do. Look, you are very welcome to the meeting today. As I say, this is our first briefing on this. We're glad to have you here. So some of our questions might seem a little simplistic at times, but you're our first one's up, so we kind of maybe need to better understand just the challenges and that this bill might propose to some people within the industry. So I think it's Vincent hold on, Vincent. Paul, I have you down as Vincent Paul McLean. Is it Vincent or Paul? Vincent or Paul? Paul. Thank you, Paul. Okay, I think it's you, but we have terrible feedback and I don't understand why. Have you only one device on in that room?
Yes.
That's it now.
No.
Oh no, it's not.
Can you hear me okay?
Yeah, I can hear you, Paul. I can hear you, Paul, but I can hear myself too.
Oh dear. Well, would you like me to start, or do you want me to hold on for a moment or two?
You know something, when you're speaking on your own, it's fine. So if you want to go ahead, that would be great.
Okay, all right. Well, good afternoon, Chair, members of the committee. Let me start by thanking you for this opportunity to address you and hopefully outline the position of retail bookmakers in Northern Ireland. By way of introduction, my name is Paul McLean. I'm the chairman of the Northern Ireland Turf Guardians Association. Joining me is our secretary, Mr. Gary Toll of Toll's Bookmakers, and fellow NITCA committee member, Mr. Michael Fee of Ladbrokes. The Northern Ireland Turf Guardians Association is the representative body for retail bookmakers in Northern Ireland. Our membership comprises large national operators, medium-sized regional chains, small independents and single shop operators. There are approximately 285 betting shops trading in Northern Ireland, and our membership accounts for approximately 260 of these. Betting is a legitimate adult pursuit, and licensed bookmakers provide an excellent service. We also provide local employment and contribute to local communities. The industry employs approximately 1,500 people, and the economic value to the local economy is estimated to be around 29 million per annum. Our association welcomes the proposed bill, and while it may not go far enough for some, it must be seen as the first step on a long road to update legislation that is now almost 40 years old. While there are 15 clauses, we see three main issues in the bill. The first being the Sunday opening of betting shops. Even though betting shops are closed, gambling still takes place on a Sunday. People can bet on course, online, by telephone, national lottery and scratch cards, gaming centres, and illegally in pubs and clubs. In 2009, a PwC report estimated 161 full-time jobs would be created and 32 million over the first 5 years would be added to the Northern Ireland economy if betting shops were allowed to open on Sundays. These figures may be optimistic now, but there certainly would be a significant jobs and economic boost. Another significant benefit would hopefully be the end of illegal betting. which denies legitimate employment, denies all forms of taxation, and in certain areas may fund paramilitaries. It takes place completely unregulated and obviously in premises that sell alcohol, a mix that has always been strenuously avoided by legislators. Workers' rights will of course be protected in the same way as is already the case in other jurisdictions. Allowing bookmakers to open on Sundays provides customers with a legitimate choice within a regulated environment, addresses the anomaly for local operators, provides jobs for local people, and increases taxation. The second major issue is that of an industry levy. The vast majority of people gamble safely, although a very small number do develop problems. Bookmakers appreciate this, and we take various steps to help. Safer gambling messages are clearly displayed in bookmaker shops via wall posters, leaflets at the counters, on till receipts, on screens, and on gambling machines. Staff training also enables staff to spot and assist anyone showing signs of problems. A self-exclusion policy can also enable customers to exclude themselves from our premises. For the past decade, bookmakers have also contributed to a local addiction service specialising in problem gambling, namely Dunlewy Addiction Services. This is the only province-wide service available to those with gambling issues. They provide a helpline and counselling sessions free to anyone. Northern Ireland retail bookmakers have contributed in excess of £300,000 to assist with problem gambling, and to our knowledge, no other sector of the industry makes contributions. The 2016 Northern Ireland Gambling Prevalence Study identified 23% of gambling being on an event or sport. This includes online and 1.6% who play machines in betting shops. So we know that at its height, gambling in betting shops reflects much less than 20% of gambling taking place in Northern Ireland. Yet we contribute 100% of the funding for problem gambling, while National Lottery Online, scratch cards, raffles, ballots, online gambling, gambling centres, machine operators, bingo clubs do not contribute at all. As can be demonstrated from our voluntary contributions to date, we are happy to do our bit to help with gambling issues, but any levy must be equitable and fair. The final issue is that of a mandatory code of conduct. As you will see from our submission, our members already adhere to and promote safer, responsible gambling. These voluntary measures were led by the industry in the absence of statutory regulation. Age verification, safer gambling information, staff training, no credit cards to be used in betting shops, no ATMs sited inside betting shops, self-exclusion policies and Dunlewy contributions are amongst the measures we have implemented. Regarding gaming machines and fixed odds betting terminals, when they were introduced, we voluntarily agreed to abide by GB rules regarding numbers and technical specifications. When the stakes and prizes were reduced to £2 in 2019, again, we voluntarily followed suit. All FOBs now have responsible gambling software installed that allow customers to set time or spend limits, along with on-screen prompts and breaks in play. I appreciate I've covered a lot of ground very quickly. My colleagues and myself will be happy to take any questions you may have.
Thank you. Paul? Can I ask you to put your microphone on mute? There, I think you're on mute, Paul. That's it. Just while we ask your questions, and then you can take yourself off mute whenever you're answering. It's just the feedback is horrendous, which often happens. I have to say, it's not just yourselves. Look, thank you for that. As I said, this is our first briefing, so I suppose I just want to initially ask, or I'll maybe just ask my questions together rather than have you mute and unmute yourself. The purpose of this, through this bill, as a committee, we are very keen that we strike a balance. We strike a balance that is appropriate to both consumers and to the industry. We are also mindful, as always, of any unintended consequences through a result of any bill. So I suppose we want to ask your opinion as is there a balance? Do you see the balance within the bill? Is there something more that we could be doing to address imbalances? I know you had mentioned around there about the levy and how that you contribute to Dunleary. Which is great, but it's a small amount because so few people do contribute the way that you contribute. So just if you could expand on that a bit more and how that could be changed. And then I also want to ask you around the illegal betting. I know the Sunday opening will be probably will be a little bit contentious, so it will when we come to further consideration of this bill. But I am also very aware, because it has been pointed out to me, that there is illegal gambling does, continue to take place in our pubs and clubs every Saturday, or sorry, every Sunday. So it's just to ask you then on that point. What is the scale of that? Is that on a worrying scale? I suppose that's what I want to ask. So that's kind of my openers. If you don't mind asking those questions or answering those questions for me, please, and take yourself off mute.
Thanks, Chair. With regards to the levy, we have no issue whatsoever with a mandatory statutory levy. It was, we found, we went looking for somebody to help with addiction services at least 10 years ago, I think 12 years ago. And we ended up with the new addiction services based in Belfast that give a province-wide support network to people with a gambling problem. From the outset, every Irish betting shop, including the Republic, actually donated towards the new addiction services, although unfortunately that has changed in the last couple of years because our counterparts in the Republic of Ireland have outsourced and found what they consider to be local services, and we would rather stay with the new addiction services. Our only concern with, so we've no issue with the paying a levy. We have. My colleague, Mr. McLean, and I personally were asked last year, where we're told we're struggling for finances as we make voluntary contributions over and above what nearly all betting shops in Northern Ireland pay, and we gladly paid them extra money to get them through a difficult period. The problem with the bill as it stands, we believe less than 20% of what happens gambling-wise in Northern Ireland happens in betting shops. 48% go to the National Lottery, 23% play scratch cards, 21% go to raffles and societies, which might be a local football club or the local church. You can mandate the betting shops may pay X per year per betting shop, but there's nobody talking to the National Lottery. We have concern about that, and anything else we mentioned. So if we had a sort of a level playing field, we'd be happier. But we have no issue with the statutory levy whatsoever. You've asked 3 or 4 questions there. I'll maybe ask Paul to talk about the illegals or Sundays.
The Sunday betting, I don't know whether you're aware or not aware. I mean, Sunday betting, you can bet almost anywhere in Northern Ireland now, apart from in a betting shop, which is the place that's licensed to take bets. You can bet on your phone in church if you want on Sunday morning. It just seems ridiculous that the only place that is licensed to accept bets is the only place that is closed by law on a Sunday. In our industry, sport, you'll be aware of, is changing all the time. So many major events take place on a Sunday. The World Cup finals take place on a Sunday. The Euro finals take place on a Sunday. Wimbledon finals take place on a Sunday. The British Open, which the executive is thankfully bringing back to Portrush again, that will finish on a Sunday. All these betting opportunities are not available to retail bookmakers in Northern Ireland. Now, people still bet on them. They bet online. They bet on telephones. They do bet in pubs and clubs, completely unregulated, and they're being forced there because our legislation keeps the shops closed. They're also being forced to, in some of the border areas, cars go across the border to do cash bets at the weekend. It just seems ridiculous that the places that are licensed to accept bets are the one place that you cannot take a bet on. I mean, as I said, well, there was an estimate in that PwC report about betting on a Sunday valued at, say, 4.2 million. I'm not sure how that was arrived at, but the problem again with the illegal betting on the Sunday is it starts off on a Sunday when, because the betting shops are closed, somebody pretending to be a bookmaker will sit in a corner and accept bets off people. Then that graduates through to Saturday or days when there's TV racing. The illegal betting really has become a big issue for bookmakers in Northern Ireland, and we have tried to do something about it. We have objected to public house licences. We have contacted the PSNI. They feel they do not have the resources or the manpower to do anything about it. But I'm sure some of the committee members will be aware of this. They will be aware of the boy that sits in the corner and takes the bets on Saturday and a Sunday. Now, that is all money that could be used for employment. We could employ people on Sunday. As I say, the workers' rights will be looked after the same as they are in the other jurisdictions where shops are open. It just seems an anomaly that you can do so much betting but not in a betting shop.
Can I add to that?
Feel free, Mr. Tolman.
I think, Chair, you asked, are we concerned about illegal gambling activity? I think Paul has articulated that we are very concerned about illegal gambling activity. But so when we talk about that, we talk about gambling, unfortunately, everybody just thinks about bookmakers and betting shops, and you don't think about the National Lottery that you can have a bet on a Sunday, or scratch cards, or the local football clubs. Good cause for their society and for their club and for their good causes, whatever that may be. I'm not knocking that, but nobody ever seems to talk about illegal casinos, which are rife in Northern Ireland, and nobody's policing it, nobody's addressing it. As Paul McLean here articulates, kind of like the police are not just policing it, and there just seems to be it's a forgotten, hidden dirty problem that nobody's addressing. And there are legitimate bingo clubs, there's some illegitimate bingo clubs, a lot of adult gaming centres which are legitimate. We are legitimate, we pay our taxes, for us it's gross profits tax. We also pay machine gaming duties, as would adult gaming centres and some bingo halls. There's many illegal casinos out there, just ignored. There's several of them through the courts at the minute. Hopefully something will happen there, but they've been there for 20 years before apparently 2 next year may end up in court. So if that doesn't go well, we may as well close, because people can bet 24/7. You can go into many illegal casinos 4 o'clock in the morning after a lot of drink, or possibly get drink in those places. I mean alcohol, and you can do whatever you want. We need policed, and nobody's policing us. We self-regulate, nobody else does.
Can I just ask further around... we're getting echo again. Can you put me quickly on the mute? Sorry. Can I just ask, around the illegal casinos, it's not something I am familiar with in any way, shape or form, and some of us have been looking blankly at each other around the room. Would you just explain a wee bit further to us, what is an illegal casino? Is it on our high streets? Is it without naming names, just where are these? How do people access these, and just how popular are they? It's not something I know a great deal about, and I don't know if there's any members around the table know a great deal about, but I'd be interested, just a wee bit more detail on that, please.
Okay, the illegal casinos could, it's very hard to explain to you where they come or they're basically clubs that could be bingo clubs, gaming centres. During the day, they will carry out what they're supposed to be doing. Then at night, late at night, they will perhaps close their doors, have a restricted membership. Machines which used to maybe take 20 pence or 50 pence can be adjusted that they will take any sort of stakes. There are a number of large poker table type machines in these illegal casinos, and they are taking over any or so much of the business in Northern Ireland. And there just seems to be, we did a number of years ago object to one in Belfast and it was closed down. But as I say, the police, or as Gary said, the police don't feel they have the resources and the manpower to do anything about them.
And what we're talking about here is, casinos, the classic casino game, most of Europe, or if not most of the world, is the classic roulette. So there will be machines. Some of them are physical machines. You actually see the ball going around, as you would see. And as we don't have a legal casino facility in or legislation for in Northern Ireland, you get it in the rest of Britain and I think to some degree in the Republic now. But you will actually see the live roulette table playing games, and you can stake as much as you want. You could have £500 black or red, or £500 on your lucky number, which might be 2, and you get 35 to 1. And that happens at 4 o'clock in the morning. And some of these places, there's machines akin to what, not all bingo clubs are bad, not all gaming centres are bad, but there are some masquerade under that guise that are open 24/7. As Paul says, come maybe 10 o'clock at night, you have to be a registered member to get in. You'll need to be recognised and buzzed in CCTV and all the rest. But they're just totally illegal, not regulated for, and you can win whatever you want. And there's no guise. There's nothing to say. A lot of these places. Sorry, I lost my train of thought there. During the day, they will have these machines, which would be akin to 40s, fixed odds betting terminals, which are in betting shops in Northern Ireland, which we self-regulate for, and we have reached stakes and prices on those to match mainland Great Britain. But there's an awful lot of machines that are out there on the market. By a flick of a switch, you can make it a 30p play during the day, and you press a button on a computer console. It'll say, right, we'll change all those. You can put up to £100 per spin on a casino game, or £500, or £5,000.
My goodness, that's shocking. So it is, and I suppose I would akin that to where we would have like a bar with a lock-in. So this is something similar to a locked door, guests that are known, word of mouth, that sort of thing, and that's how this is happening. And that's scary amounts of money. So it is. So it's certainly something. Look, thank you for that as well. Members, can you notify any if you want to come in and ask questions? I know Mark Durkin has his hand up. If we could bring Mark in. And then Paul. Okay, Mark.
Thank you, Chair, and thanks to the gentleman for the presentation. I want to declare an interest of source. It's not really one, but it should be out there. Anyway, I recently met Mr. McLean at an event in Derry, the Derry Journal People of the Year's event, but I can assure people there was no discussion about legislation or anything remotely like it, but I just wanted it out there in case any photos start appearing or do you know any shadow being cast on either of us. Now, I have raised though previously, Chair, and even if we go back to this being debated in the Chamber at second stage, my concerns that some aspects of this bill seem to single out, established bookmakers or those that have shops here. It seems to single them out just because they're here, because they are established, because they have an address. Let's hit these guys in terms of the levy. And I think they've outlined that a bit. Currently, there is money that they do pay. I wonder, might it be interested to maybe hear at some stage from the Dunleary Centre. I don't mean to verify what the gents have been telling us here, but just in terms of what they could do with more money and what they do with the money that they do receive in terms of helping people with problem gambling. And I'd in no way say that betting shops don't have a responsibility or indeed don't play a role in terms of problem gambling. But I was going to ask, given the prevalence of online betting, and I can't remember the statistics that were quoted there, and people can bet and bet and bet, you can use credit cards and keep going. Within your shops or betting shops here, and I know there's a voluntary code of conduct that you adhere to, but is there ever a case where you'll say to someone, or your staff will say to someone, no, sorry, like a barman would say, sorry, you've had enough? Are your staff instructed to tell people, no, sorry, you've lost enough today? Or is that naive of me to think that could or might happen?
Yes, Mr. Durgan, I send a lot of my staff, senior staff, on training courses. Some of them organised by the Addiction Services, some of them organised through our counterparts in the Republic, being the Irish Bookmakers Officers Association, the chairperson of which is particularly good, organises at least one course a year. So I regularly send groups of members of my staff. Obviously, I can't send them all on Monday or I have to close the shops down. But I send regular groups to the Dunleary Addiction training days and training days in the Republic. And we're just trained, my staff are trained to notice what becomes different. Most people, and I can't deny that some people develop serious problems with gambling, and some of those problems, most people, and we consult with the Dunleary Addiction Services every year, at least once a year, on a normal course of events. I missed one last year. But a lot of it's cross addictions. People may start in a betting shop and then they go online because we're not open at 11 o'clock on a Saturday night after they've had a few drinks. We're licensed for a reason. We're licensed to limit the numbers so that we don't have clustered betting shops on the high street and everybody can walk into a betting shop. We're licensed to restrict the numbers, possibly restrict the hours, but definitely, keep alcohol away from gambling, because it isn't a good mix, because people have too much alcohol, and I have no issue with alcohol whatsoever, but if too much alcohol, you might have a bet that you shouldn't have had, or had an extra 10 bets that you shouldn't have had. And if you can go online and say with a credit card, that's particularly bad. I was very pleased when the Great Britain banned credit cards for use in betting shops and online if you're licensed with the Gambling Commission license in Britain. But back to your question, sorry, my staff are trained to notice differences, and we're sort of somewhat of a social hub, a bit like a pub where you might get that lock-in. You're only going to be locked in, if you're well known. But my staff will recognise, well, that's John. He's in 3 times a week, and he has a £5 bet on a Tuesday, Wednesday, and a Saturday on a soccer accumulator because he really likes football. And then if all of a sudden he changes his habits, my staff are encouraged or told deliberately, go and talk to John and say, John, what are you doing here? What's changed? How come? Do you have a problem? So we miss some of them. It can be very, very difficult when somebody walks in off a high street in a busy town. It's very easy in a small town, and I'm in an awful lot of small towns as well, because you get to know 95% of the customers. It's a bit difficult in Belfast when you can go 5 or 6 streets and we don't know who John is, but we do get to know them, and if habits or change very specifically, or people have unusual amounts of money and are not dressed accordingly, my staffer said, are you okay to do this? And gaming machines are more prevalent on that regard, as opposed to the traditional, where Paul and I's background would be from, is traditional over-the-counter OTC, as we would call it. Having a bet on the horses, or having a bet on football. It's easier to hide playing a gaming machine, but we don't have the big issues with faulties, which definitely were prevalent in the southeast of England, and that restriction, which we self-regulated from £100 maximum stake on a faulty down to £2 stake. Arguably, we didn't need to do it, but we felt it was a socially responsible thing to do. Therefore, we copied.
Just to add to what Gary was saying there, yeah, I mean, the staff do go to the NUI to explain how to try and spot something that's different. It is sometimes very difficult to approach customers. Sometimes people take it very badly. So it is sort of a knack of saying to someone, look, that's not your usual type of a bet, or what's going on there. A lot of people do take offence whenever you try to restrict or ask them what they're doing. But that is all part of the training that's supplied by the NUI. I mean, as Gary says, we all send our staff there. They're the people that know what they're doing regarding the problem of gambling. We meet them regularly. We ask them how we can help with spreading the message, if there's anything extra they need us to do. But I mean, we have no influence. It's been muted sometimes that bookmakers have a big influence on how these addiction services are meted out, or who decides who qualifies for it. We meet regularly. We only go to help and to ask what sort of assistance they require, how the service is going on, but we have absolutely no input in anything or any say in how to provide their services. As Gary said at the start about the levy, we do contribute to a levy. We're happy to contribute to a levy and to continue to do so, but all we're asking for is an equitable and fair playing field. There are so many sectors of the gambling industry which pay nothing and don't want to pay nothing. From your own prevalence study, or the executive's own prevalence study, almost 50% of regular gamblers were citing the National Lottery as being their form of gambling. The next one down was 24% who use scratch cards. I mean, those are National Lottery products. The National Lottery is also online, but they make absolutely no contribution to gambling in Northern Ireland. The other big issue is the online gambling. They make no issue, and they make no contribution. I know you've been made aware of this. We're just concerned that if a levy is introduced, it will be introduced just to hit the bricks and mortar operators, because you can't legislate for those outside NI, and we feel that would be vastly unfair.
I think I'd actually made that point previously myself in terms of an inequity there. Now, I think you says in your response here that you would welcome a mandatory code of conduct. There's reference to your current voluntary code of conduct. How would you see that mandatory code of conduct should look? And I mean, like, you're here and you're telling us the good things that you guys are doing and the responsible things, but are you speaking for all betting offices, like who all falls under your membership? And I welcome the stuff that you two seem to have done in terms of the fob tees and reducing the stakes there, but is everyone doing that? And I was going to ask you as well, I know about the prevalence of machines in betting offices. They are in lots of other places as well. I mean, you've referenced the casinos, the legal ones, as well as bingo halls and that, but the likes of betting machines in bars and like bars, at least it's only over 18s going on there, but I know there'd be takeaways and stuff like that. I'd be in occasionally, and there are betting machines in them. What's the story with them?
Okay, well, to go back to your first question regarding the mandatory code, as we said in our submission, yes, we're happy for there to be a mandatory code. Now, we represent probably 85% of the betting shops that are trading in Northern Ireland, and they do apply the regulations and the things that we have pointed out in our submission. We would be happy for this code to be mandatory. I mean, our licences are renewed every year. If you break the law or do something wrong, anyone can come along and object to your licence. The police can object to your licence. The department could object to your licence, and you'll lose your licence. So that is the ultimate deterrent. Bringing in a mandatory code is quite a good fix, because it will allow the legitimate operators who we represent to be on the level playing field with those who are not playing the game and who are having more machines or higher stakes, who do take credit cards. So the mandatory code of conduct, as far as the legitimate operators are concerned, would probably be a boon to us. We would be very pleased for that to be introduced. You mentioned machines and fob tees. A couple of things I'd just like to clarify about those fob tees. I mean, in the past, when it was £100 play, that has now been reduced, and we voluntarily brought it down to £2. When it was £100 a play, it was a myth that you could lose £18,000 in an hour on a fob tee. That just, for two reasons, was impossible. One, it was physically impossible to put that amount of money into a machine. You couldn't put, I think it was calculated at £100 a spin, 3 spins a second, 3 spins a minute, 60 minutes in an hour. That equates to £18,000. You couldn't put the money into a machine that quickly enough. Secondly, the odds of having 180 unsuccessful spins are higher than winning the national lottery. So this is a myth that has been bandied about in press, that you could lose 18. At the £100 level, you could never have lost £18,000 in an hour. That is done away with now. It's now, as Gary said, we voluntarily reduced it to £2. So the issue regarding fob tees has virtually, we feel, gone away because of this great reduction in the stakes and prizes. The other point you made about machines in other places, pubs, clubs, I've even seen them in taxi ranks and fish and chip shops. We feel they're completely unregulated there. I don't know what size of stakes and prizes they are they're using. I don't know whether this bill, if it was a mandatory code of conduct, would have anything to do with that. Perhaps if it applies to machine suppliers, that they're not allowed to supply taxi ranks, chip shops, pubs and clubs with machines that they shouldn't have. I think, again, that is the equity point. If we're going to have a mandatory code of conduct, the mandatory code of conduct has to apply to all sectors of the industry. It has to apply to gaming centres. It has to apply machine suppliers. It has to apply to bingo clubs. Again, we're only asking for we will welcome a mandatory code of conduct. We will do whatever is said in this mandatory code of conduct. But again, we would ask the department and yourselves to make sure that the mandatory code of conduct is fair and equitable across the industry.
Okay, thank you. And just finally, in terms of the Sunday opening, and the chair touched on this and says it could be contentious, and I think she's definitely right in that regard. You've outlined the rationale behind that, which I accept. I appreciate that others might not, and to see something in there around protection for employees who couldn't or wouldn't be able to work on a Sunday due to religious grounds. I was wondering in terms of making this maybe more palatable for those who would be opposed to what they see relaxation of gambling laws by allowing shops to be open longer. Would you guys be open to some sort of restriction on hours per week, where you can choose to use a Sunday in place of another day, or a half day on a Sunday in place of a half day somewhere else?
We'll be happy with a restriction in hours on a Sunday. We have no issue. We definitely do not want to be open from 8 o'clock in the morning. And most betting shops in Northern Ireland don't open until 10 o'clock in the morning. You know, if you get to London or Dublin, you might see shops open 8 o'clock or 8:30. It really is just not viable here. It's just not. I think it's a societal thing. Just nobody goes into. Anybody who's tried it, doesn't work. Definitely don't want to be open for my staff and their sanity. You know, I'm very happy that they can withdraw from working on a Sunday. I have at shops in Scotland where staff have, through religious reasons, didn't want to work on Sunday. Suits me fine. You know, if I employ somebody 40 hours a week, I don't need them to work 48 hours or 56 hours. I'm happy to employ more staff. The more staff that tolls have working in the shops, I'm not sure that's good for the economy, but it's better for my flexibility and covering days off and all the rest. So, we would propose, and I've discussed this with Paul many times in the past, if we get something like 11:30 to 6 o'clock, we'd be delighted. Because, as Paul has mentioned, you know, most, with the exception of American golf, by and large, most major sporting events take place on a Sunday, and it's all between 11:45 and 5:45. You know, the kick-off from the Premiership and the football, you know, the darts final, the snooker final, the big rugby matches, you know, and that's what our customers are looking for. You know, they have a demand to have a bet during those hours. Currently, like, I know towns on the border. I'm not talking about your town, Mr. Durgan, but I know towns on the border. Sorry, definitely nothing to do with you. But you know, certain towns, you know, buses will go from one side of the border to the other just to bring them to betting shops and pubs. You know, because the betting shops are closed in the north. So hopefully I answered your question, Mr. Durgan.
Well, if I could just interject there, the idea that you were saying about swapping days, I don't really see that as being viable. I mean, if we're trying to restrict illegal betting, then that's going to close a shop on another day. So that brings back the illegal betting issue. Secondly, on a logistics point, as far as we're concerned, if you close a shop on a Tuesday or a Wednesday to allow it to open on Sunday, I mean, customers get out of the way. I mean, they'll sort of think, well, why is it closed today? It would be the death knell for certain shops if you're messing about with the hours. Customers expect the shops to be open, and if they're not open that day, they think there's something wrong. We have got instances of it where we close at night in some shops, and some shops we don't. If you close at night, it definitely affects the day business. So to close a shop on a Tuesday to allow it to open on a Sunday wouldn't really work, to be honest, Mr. Dirk. I mean, yes, we're happy with restricted hours, as Gary has said there. The slight issue with having set restricted hours is when you're in the winter, the racing starts about 11 o'clock, 11:30, and will finish by 3 or 4 o'clock, obviously because of the light. When you're in the summer, the racing doesn't start to perhaps 2 o'clock and will go on to 5:30. So to have set restricted hours would be very difficult in our industry, because in the winter they would have to be different to in the summer.
Okay, thank you. And then just very finally, and it's just for a bit of clarity really, it's in relation to clause 12 and then a wee bit on clause 13. And clause 12 is to do with cheating. I was just wondering what sort of form the cheating might take, how prevalent that is, how much of a problem it is. Like I watched a documentary recently on Barney Curley. I don't know that sort of stuff goes on with great regularity or frequency. And then in 13, enforceability of gambling contracts. Have you ever, or any of your members, been in a situation where bets aren't paid out to punters, and why would that be?
Well, to start with your second question first, the enforcement of bets. No, we have to pay out bets. If we don't pay out bets, words goes around very quickly. There's no point in betting with them because you can't get paid out and you get a winner. I don't know why this anomaly had been in the legislation. It was changed in GB and it was changed in the Republic of Ireland. So, as far as the enforcement of bets goes, it won't be an issue that's why I didn't speak about it in the introduction. It won't be an issue as far as bookmakers are concerned, and there is very little, if no, credit betting anymore. Perhaps in days gone by, people were allowed credit, and then there might have been an issue regards the enforcement of bets to the customer. But with the way technology has gone, and there really is credit betting, and the enforcement of credit betting is a thing of the past and won't really raise its head. With regards to the cheating, I know you mentioned the Barney Curley TV programme. I don't really see it as something to do with that. I mean, people, if you were to take it to that nth degree, owners run horses down the field once or twice to get their handicap better and perhaps to get a better price the next time. You couldn't claim that as cheating. I don't know what the cheating would involve. Maybe it would affect machines which aren't properly regulated, machines which are maybe set that they don't pay out. Not that I've ever come across any, but as far as the cheating's concerned, I don't know that there's ever been any. And as I say, we have yearly renewals of shops. So as far as the cheating's concerned, I don't think there's ever been any instances of bookmakers either not paying out or cheating. For customers or punters to be able to prove that they cheated at something, it's going to be very, very difficult, I would say. Okay,
thank you. And then I suppose on the enforceability of gambling contracts, you'd spoken earlier about illegal bookies, and I do of their existence. I don't know how prevalent it is, to be honest, but I do know that there are illegal bookies that operate. There'd be no enforceability on anyone who's unregulated. I guess it would probably be, or possibly be, unsafe for a punter to pursue that in some circumstances. But no, thank you, gents, for those answers. Thanks, Chair.
Okay, Mark, thank you for that. Members, we literally have 10 minutes left for this briefing session. So, Paul, you'd indicated, can we get straight to the point? And also, Gary and Paul, can you respond in a more succinct manner, maybe just at the end now?
Yeah, I had enough time there, Mark, to run a book on how long you would take there. Just on the issue about the Sunday observance and opening, I get your whole argument that because you're not playing you can do anything on a Sunday with your phone. And I get that argument is a valid one you make. But it's just not for religious-minded people on a Sunday that you need to protect. It's people that just want common time with their family. If husbands or wives are off on a Sunday, if their children are off school on a Sunday. So, and I know you responded by saying that you do think that Clause 3 allows sufficient protection for those working on a Sunday in this industry or choose not to work on a Sunday. But all you're doing in Clause 3 is extending the protections from a track and other places into the bookshop, so licensed bookshop. So do you think that the 1985 order, which is quite old, affords enough protection for people, religious or otherwise, to not have to be working or pressurised into working on a Sunday?
I would welcome, a copy and paste from the British Act, or that provides the rights for our workers to work on a Sunday. If I've got somebody in a 40-hour contract, pretty much full time, 37 and a half hours, I want to employ extra people. I want to provide more employment out there. So I can't force some. I will not, on a personal level, force somebody to work on a day they don't want to work on. But I welcome protection for workers for whatever reason, whether religious or family reasons, do not want to work on Sunday. I have no issue with that whatsoever.
Okay.
If it's an extra 14% of hours, my staff, my shops will be open. If I've got 14% more staff, I employ 250 people.
Mm-hmm.
If I'm employing 14% more, if that's an extra 50 jobs, 40 jobs, so is that not a good thing?
Yeah. No, listen.
I was just going to interject there two other things. I mean, as Gary said, we are happy if the legislators want to toughen up or come in with something else to ensure that staff do not have to work. If they don't want to, if they have got any religious reasons not to do so. Another very obvious reason why you don't want them working is if somebody doesn't want to work that day, the service they're going to provide to your customer is going to do nothing but lose your custom. So it's in no one's interest that people are forced to work whenever they don't want to.
Okay.
But certainly, as far as you're saying, if they want to toughen up the bills, we'd be happy with that.
Okay, thank you. With regards to credit cards, do you accept credit card payments?
No, we do not accept credit card payments in any shops.
No, that's voluntarily. We followed the British legislation, and I think I said it earlier. I always disagree. People should not bet with money they don't have. Credit cards, by definition, is money that they don't actually physically have, possibly don't have in their bank account. We agree. We concur as an industry and as an association. We said, right, we're stopping all this. We didn't have to, but we stopped it. Okay. I own a software company that supplies EPOS systems to shops, not to call centres. I just wrote it into the software. So if it's debit card, you can't take it.
So would you support then an amendment to make sure that doesn't come into play in the future?
We're more than happy. We don't take credit cards. We don't want credit cards.
Okay. Do you take debit cards?
Well, personally speaking, for my company, not until the lockdown, we didn't take debit cards. We only introduced that because of the tap and the touch, and less because of the pandemic. We do have restrictions on how many times you can use your debit card and how much you can spend on it, because we don't want people to lose all the money in their account. Originally, it was the advantage to the betting shop was you were limited by what you had on you. No bookmaker wants people to empty out their accounts either via credit card or debit card. So, I mean, yes, we do take debit cards now because everybody uses a debit card. Everybody wants to use a debit card instead of cash. But there are restrictions in place as to how much you can use your debit card, how many times you can use it, and how much you can use it for, how much you can bet.
And I agree with Paul. I had very few shops that actually had merchant terminal machines, that's what they're called, prior to the pandemic. After the first lockdown, a lot of my staff were uncomfortable coming back to work, but were very uncomfortable using cash, as you've probably seen yourself in shops or wherever you may have visited. So it gives my customers and my staff some sort of confidence that, well, we're not dealing with somebody else's possibly virus-covered.
Understand. One more question. If there was a cap on debit card spending, what would be reasonable?
Are you talking about a cap per day, per spend per day, or per week, or what? Or per use?
I'm open to any suggestion.
Well, we have a current cap of £200 is the maximum you can use your debit card for. So
Per day?
We'd be happy. Per day? Yeah. Yes.
Okay, thank you very much.
Okay, thank you. I thank you guys. I know we've got really tight for time, so I'm unable to bring any other members. I mean, I know Kelly probably would have liked to have asked a few questions.
Okay.
All right. I really appreciate you coming in today. I've certainly learnt plenty from listening to you. I would hope that if we do need further information of you, as we progress through the bill. It was good actually to have you come in here first, I suppose, but we might require maybe some more explanation from you as we go through the bill. You would be very open, even if it's not in person, to maybe getting back to us in writing in some way even, though we do prefer it in person, absolutely, but we understand that trying to work into diaries is not always possible. So can I just thank you for kicking us off then in this new bill in front of us. It has been very interesting indeed, so thank you.
Thanks very much, Chair. Thanks, Billy.
Thank you now, bye-bye.
Thank you, bye-bye.
All right, okay folks, I am going to move swiftly on then to agenda item 9, which is correspondence. Members, you'll see the correspondence memo is at page 401 of your meeting pack. Can I draw your attention to a request from the Northern Ireland Sports Forum, who have asked to come and brief us on the betting bill at page 566. Are members content to receive a briefing from the Sports Forum? I think that would be good. Yeah? All agreed?
Agreed.
All right. And also, members, it's not in your packs because I didn't get it sent in time. I also received a request from Oasis Gaming, that own a chain of gaming stores right across Northern Ireland. They want to come in and brief us in the bill as well. So can we get agreement on that also?
Yeah.
Great, super stuff. I have nothing else further I need to bring up under correspondence. Is there anything any member wants to bring up? It's in correspondence. Are we content then as drafted? Content?
Yeah.
Content.
Good
Yeah.
stuff. I'm going to move you on then to agenda item 10, which is our forward work programme. Just to advise, at the meeting on the 2nd of December, we will continue our deliberations on the Private Tenancies Bill. We will also receive a briefing by Raise on the betting bill. See how it's been just, I have it written down as betting bill now instead of that big long title. And there will be a departmental briefing on fuel poverty payments and the sub-regional stadia programme. So there's a big mouthful. So members, okay, agreed with that?
Yeah. Agreed.
All right. Then can I move to AOB agenda item 11? Do many members have any other business? Speak now? No? Okay. I'm going to
Sorry,
move.
Chair.
You always do this. Go ahead.
Right. I've come from one extreme to the other in these bloody meetings. No, I was just wondering, could we maybe get some sort of briefing from the department, or maybe it'll be the housing executive might be better to ask, and it's with regard to, I don't know if other members will have come across this in their constituencies, but leaseholders or owner-occupiers, people who've bought former housing or bought housing executive properties in, say, their maisonettes or flats or apartments, and in the small print, which is fair enough, they undertake to contribute to any maintenance schemes in common areas. It's just we've had a number of people coming into this over the past while with these, that people are being presented with estimates that they're going to have to pay £8,000 towards stairwells getting painted and things like that. I was just wondering, could we maybe get something from the department on this situation? You know, it's completely untenable for a lot of these people to pay this money, and I cannot understand why the housing executive are trying to recoup it 100%. I mean, we've been enough of them in the past for not doing things like that, but it's just, I think some of the demands are completely unrealistic as well.
Mark, yeah, absolutely. I've had a case of flats within Rathcoole where residents and homeowners were getting bills of thousands. I asked the housing executive for a breakdown, and they sent me out a breakdown of what each part of the bill was, and I might not have the correct figure here, but memory serves me right. It was like £200 per household for removal of one aerial from the top of the building. Like, how can what a nonsense when the majority of the people there have Sky TV dishes. What are they actually paying their service charges for? Is that not for the upkeep of common areas? Yeah, it's madness. And then when you look at actually another one I have at the minute is where a block of flats needs a new roof put on, and that then the price that is going to cost every tenant within that building, it's thousands. So I agree 100% with you.
And private people are being asked to pay public prices. That's the thing, when they could get Mickey down the road to do it for a quarter of the price. It's farming.
That was my argument on how much does it cost to remove an aerial from a 3-storey building. It doesn't certainly cost whatever, £20,000. I'd love to know. I would take up that job myself if that was the case. Tell you. Put a tender in for that. No, I think that's a good idea. I think we'll ask those questions.
Chair, could we get a written briefing just in the first instance?
Yeah, let's get a written briefing in the first instance, but it certainly is a problem that is occurring more and more. I know in my own area, I have especially a lot of masonettes and flats certainly within that North Belfast side, especially even within Rathcoole. And, I can understand the frustration of tenants. It's absolutely dreadful when faced with these bills. I'm happy enough. We'll do written first, and if we need be, we'll carry on and get an oral. Any other business, members? No? Okay, look, I'm going to move on then to agenda item 12, which is date, time and location of our next meeting. Our next meeting will take place on Tuesday, the 30th of November at 9 a.m. in room 30, when we will continue on our deliberations of the Private Tenancies Bill. Thanks, members.
This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29. This is the Northern Ireland Assembly Committee Room 29.